John. People against Michelik, Megan Elise Michelik, file 23B143326. Yeah, right up to the podium, please, ma'am. Your name?
My name is Megan Michelik.
What do you think I'm thinking? What do you think that I'm thinking right now? Like, where you been? You didn't show up for a show cause in 2023.
Oh, because I'm
That's the-
going through a domestic violence situation.
How much do you have today?
I don't have anything today. I was trying to see if there was,
Where do you work?
I'm currently not working. I was shot a couple years ago.
Shot?
Yeah. My ex shot me. I was going through a domestic violence situation. And,
Jeez, I hope he's in prison if that was, whatever, we don't need to talk about that. You can't come in 2 years after the fact and start asking for time to pay is my point. Do you get me?
yeah, I understand. I just recently kind of got out of this situation and kind of just getting my life back on track. So that's.
How are you going to support yourself? How are you going to support yourself?
Right now I have domestic violence help. Domestic violence advocates have been helping me.
Tell me how much you can afford to pay weekly here.
The
Need you to do $100 weekly. You haven't paid anything in 2 years. You're not working.
I do have help that somebody who's helping me get my tickets paid off so I can kind of get my license back and get.
Pay 50 per week on file A beginning on October the 17th. That's a week from Friday. Then pay on the B file, okay?
Okay, yeah, I was just trying to see if there was a possibility to be able to get anything lowered for,
You haven't been here in
Because I
2
did.
years.
because I did get my insurance and registration and everything after the fact that that's what it's. I just wasn't here because of the domestic violence situation. I do have a domestic violence.
How long is your husband? How long is your boyfriend or husband? Was it your boyfriend or husband?
No, it was my ex-boyfriend.
How long has he been in prison?
He just actually recently got out of prison. He's on
So how long was he in prison?
years.
Okay, so he was in prison. You should have come and talked to me. Listen to me, please.
Yeah.
You can't do this. I'm sympathetic to what you went through. I don't believe in any of that stuff. But you can't come in here 2 years later and it's the fines, okay?
Yeah.
All right. If you somehow come up with a lump sum of most of this or some of this, or at least a good portion, you come in and talk to me. I'll consider reducing your fines, okay?
Thank you. I appreciate it.
Good luck.
Thank you. Oh, yeah, I'm sorry. What about my warrant?
It was already-
I have a next warrant.
It was already canceled. We canceled it today.
Okay,
Okay?
thank you.
All right, good luck.
Thank you. Thank you.
Thank you.
It's right here. Okay.
LVNV versus Gary Asciutto, 2404968. Can I have a pretrial order down there? Actually, I got one right here. Okay. Good morning, everybody. Your names, please.
Good morning, Your Honor. Maxwell Quinn, P86016 on behalf of plaintiff.
Is Gary Asciutto here?
Your Honor, I did not have him check in.
Well, counsel, then it was scheduled for 8:30. I give everybody 15 minutes. He's not here. If you'd like, you can take a default judgment.
That's what would be my request at this time, Your Honor.
All right, go ahead and give me a breakdown. You prayed for $6,166.44. That's the principal sum, true?
Defendant has been making payments, and I will give you the breakdown as it currently stands. He's paid down the balance to $4,937.44. We've incurred court costs of $133.75, plus the statutory $75 attorney fee for a total judgment of $5,146.19.
Defendant failed to appear. The case was scheduled for 8:30. It is now 8:57. Default judgment will enter. You can submit your default judgment. If you could do that this morning, I would appreciate it. Okay?
All right, will do, Your Honor. Thank you.
Thank you. LVNV versus Christina Ferrari, 2500371. Your name, ma'am?
Christina Ferrari.
Mr. Quinn, is this yours? Oh, I'm sorry. How are you?
You're,
Not Jack Francis on behalf of plaintiff's attorney.
Good morning. Did Ms. Ferrari file a answer to complaints? I set aside the default judgment on August 26th and said defendant has 21 days to answer the complaint and file affirmative defenses. And then I set a pretrial for today. Ma'am, did you file an answer to complaint with the court and send it to the plaintiff's attorney?
Yes, I did.
Is that true, Lisa? Linda, rather?
Judge, if she did, you should have a copy in that packet there. I usually make a copy of the answer. No?
When did you file this, ma'am?
My mom came in and did it for me. I work all the.
Slow down. Linda, will you please look over there and see, did you receive one, Ms. Francis? Your office?
That's what I was just looking for.
I have it. I'll bring it down.
Okay, thank you. All right, so that being said, we'll go ahead and conduct a pretrial.
So after the hearing in August, we did not receive any paperwork. We did send her a ballot packet and she still has not returned that as well.
All right, is it NAGJBOT?
JYOT.
NAVJY?
Oh,
Thank you. And then the last name is FRANCES, right? CIS. Sorry about that. What's your P number again?
232.
All right, let me see what she's brought down here. Ma'am, do you dispute this debt?
Yes, the credit card was stolen.
Okay. All right. Well, let's set it for a trial. I'll have some discovery and allow you guys to conduct discovery. I'm going to double check the answer when it comes down here. But in the meantime, I'm going to give you until, thank you very much. This was filed ma'am, you filed this in April. You have to file an answer to the complaint, ma'am.
Yeah, my mother was supposed to, she said she dropped it off with you guys.
She didn't. You can't, listen to me very carefully. You know, I'm going to give you a break with, how do I say this? You got to represent yourself appropriately. If you're going to represent yourself, you have to either admit or deny the answer to all the allegations in the complaint, or state that you are without sufficient information to form a belief as to whether or not the allegation is true. They just handed me something from Maple, and that's the one I have in the file. I told you on August 26th to file an answer to complaint. The fact that your mother didn't bring it here, and if we don't have it here, she never filed it here.
I did it and I gave it to her and she was supposed to take it
Yeah,
there.
that's what it
And she
is.
said
So
that she did. She
Yeah.
did do it.
Man, we don't lose things in the courthouse here.
I mean, I
Okay?
understand. I'm not accusing anything like that. I'm just saying I did do it and I did give it to her. Now, I'm not sure if she dropped it off in the right spot.
I'm sure she didn't because we don't have it. Okay.
Okay.
And you're not following the rules very well. Why don't you bring your answer to the complaint up today? If you
I'm
file.
at work right now. I don't get days off, sir, and I'm already not able to pay I don't make enough to even pay my bills right now. And I'm at work 40 plus hours a week.
Well, I can't fix that for you. I asked you to do something you didn't do, and I'm inclined to grant them a judgment. You can't just file a 5 or 6 sentence letter. And I know I would have explained this to you. I set aside the default for you. You're not paying very good attention. Miss Francis, what do you want here?
She hasn't returned our paperwork, so I would ask for a default.
Your paperwork, what do you mean your paperwork?
Send her a fraud affidavit. She never returned that.
I mean, you gotta pay attention here, man. I'm gonna let you take a default. I'm sorry. I'd like to help you again, but I've set aside the default. I gave you a further opportunity to answer the complaint. They sent you some fraud paperwork. I'm sorry. I will be happy after we're done here to set up a payment plan for you if you would prefer. Go ahead, tell me what you have coming here. 103,646 principal sum, true?
Costs are $92.03. Attorney fee of $75 for a total of $1,203.49.
You can submit a default judgment. Now, ma'am, I'm going to ask you how much you can afford to pay on that judgment, either weekly or bi-weekly.
I could do 100 bi-weekly.
Okay? Can we start that next Friday?
I just got to see when my next pay date would be. Could we start it on the 17th?
That's what I meant by next
Okay.
Friday. I'm gonna make
Yes.
it the 20th.
Okay,
I'm gonna make it the 20th. Do you, so put that right in the default judgment that I ordered installment payments, okay?
You
Okay, hand it up. Now, how do you want her to pay this?
can go on our website. It's RVO.
Write this down, ma'am. You can go ahead and give it to her.
RVOlaw.com.
rvolaw.com. Okay?
okay,
Or you can call the phone number at the law office if you're having any difficulty. You have to pay $100 bi-weekly beginning October 20th. So long as they do that, you do that, they cannot garnish wages, okay?
okay.
All right?
Thank you,
I
Your
wish-
Honor.
I wish you well. Good luck. Thank you.
Thank you.
Thanks. Nice to see you. S&D Investors versus Ladero Garner. 501355.
Good morning, Your Honor. Dan Goldman on Zoom, 64231 for the plaintiff.
Where is Ladero Garner? Mr. Garner, you have to start your video, please. Mr. Garner, there you go. Your name?
Daryl Garner.
All right, so I'm looking back. I said defendant was to file amended answer to complaint within 21 days. I set a pretrial for September 15th. That was back on August the 12th. And then I made a note, plaintiff attorney will file a motion to strike amended answer to complaint. And we set a pretrial for today. Is that all I'm doing right now, counsel, is setting the,
Well, Your
Yes.
Honor, forgive me. Our concern is that you did order him to file, he just filed a letter answer. You explained to him why it was important that he answer as to each one. You know, his generic answer was, I have no knowledge of this, but the complaint was specific, including where he lived. So that's just a ridiculous answer. This is the third time we've been here. You ordered him to file another amended answer. He did not do that. We have filed a motion to strike as you instructed us to do. The time has come, I think, for this case to end. This is the third time we've been here. I don't know how many more chances this defendant has to have. And I will say by way of background that we have reviewed the media in this file. There are credit card statements in this file that I think clearly show that this credit card was used by the defendant. There were payments that were made by the defendant. So any implication that this is not a debt of the defendant, I think is ridiculous. But regardless, the court rules are clear. The time to file an answer, a specific answer, has come and gone. We request this motion to strike and we ask for default judgment, Your Honor.
Give me 1 second. So you're telling me, and Linda, I want you to confirm this, please. He never filed an amended answer to complaint after I ordered it on August 12th.
After September 15, Your Honor.
Let me double check in the, on base.
Well, I just wrote down that I ordered him to file an amended complaint within 21 days instead of pretrial for September 15. And then on the 15th, you indicated you would be filing a motion to strike the amended answer to complaint. I'm asking you, did he file one?
I filed a complaint with the credit bureau.
You filed what?
This is not my account. What?
He said he filed a complaint with the credit bureau, Your Honor.
What?
And also you filed a complaint with the court.
Wait a minute, Mr. Gardner. Whoever is talking to you, they can't do that, okay? Would you please ask them to leave the room? Mr. Garner, would you please ask them to relieve the room?
Yeah.
Your Honor, the only answer we received was on September 2nd.
Okay, good. Let me see it. Can you bring it down? I don't think I
Sure.
have it here.
Okay, I'm sorry.
You're all right.
I don't think you could find it last time, Your Honor, and I thought it was.
Unless, is it this one that was filed August 29th? I'm the defendant in this
Yeah,
case.
Yes, that's the only one we have.
I filed a complaint. What?
Why are you talking to other people, Mr. Garner? Please, Mr. Garner, Mr. Garner, please don't do that, sir. Okay? They don't have the right to be representing you or making suggestions to you, okay?
Hey.
So just let's relax. Thank you very much. I sense your frustration, Mr. Goldman, but
You know, I mean,
Mr. Garner,
yes.
would you please stop talking to somebody else there, sir? I would really appreciate it. Maybe they just need to leave the room and then you won't be tempted to interact with them. Can you ask whoever's there to please leave the room? Did you see his answer, counsel?
I did, Your Honor. And as we indicated, I think even on September 15, this answer continues to be absolutely deficient. We sent a very specific complaint. For instance, Your Honor, and we mentioned this in our motion to strike. We asked him, for instance, on paragraph 2 of the complaint, it states that defendant lives at 24182 Canarska Drive, Brownstown Township, Michigan. And obviously the defendant knows if he lives there or not. So an answer that states, I denies the allegations due to lack of sufficient knowledge is garbage. And the court rules don't allow such gamesmanship, neither should this court. And in fact, Your Honor ordered him, I think twice, to file an amended answer with a warning that if he didn't do it, he would be held in default judgment. Your Honor did that again on September 15, and he has not filed any subsequent answer. This answer is woefully deficient. It is against the court rules. It is against the court's specific instructions, and therefore it should be stricken and default judgment should be entered.
This is not my account.
I'm sorry.
Well, then he knows that, and he should have said that.
What did you say, sir? I didn't hear you.
This is not my account. Waiting for reply from the credit bureau.
Waiting for reply for what?
From the credit bureau.
The credit bureau has nothing to do with us, Your Honor. That's what he's talking about. We have credit card statements that show a balance prior to the complaint mailed to the.
I've heard enough. I've heard enough. I've heard enough. Mr. Garner, I have given you sufficient opportunity to file an appropriate amended answer. You did not do that. I'm going to strike the answer and enter a default judgment, and then we can talk about payment. Counsel, go ahead.
Your Honor, the judgment requested is in the total amount of $2,923.47. It's broken down as $2,699.07 for principal, total costs of $149.40, statutory attorney's fees of $75, $2923.47 is the total, plus a.
But I'm going to go ahead and enter a default judgment. So, counsel, prepare your order, please, striking his answer, entering default judgment in the amount of $2,923.47. Sir, are you working?
No,
How can you pay this? How much can you afford to pay, weekly or bi-weekly?
I dispute this debt.
I know you do. That's fair, but I just need to know how much you can pay.
SSD.
Whoever's talking back there, I'm going to tell you one last time. Get out of the room. Who is that, Mr. Garner, that keeps deciding that they're going to interject because we're on Zoom when they would never be able to come up here to the court, to the podium if you were appearing in person in pro per? Who is that? Mr. Garner?
Yes,
Who is that?
it's my friend.
Oh, okay. Well, that narrows it down. What's his or her name? What's her name?
April Garner.
April Gardner, listen to me very carefully. You say one more word, I'm going to initiate a show cause. Do you understand what I'm saying, Ms. Garner?
Yes.
Good. Don't say another word or I'm going to initiate a show cause. Counsel, there's nothing more for me to do. Sir, if you want, you can file a motion for installment payments. In the meantime, Mr. Goldman, you can present your order, the order striking amended answer and entering default judgment in the respective amount that we just discussed. Thank you very much.
Goodbye.
All right. Mr. Gallup, can you just show your face here momentarily? What time do I have that mount case with you today?
I think you had it at 1:30, Judge, via Zoom.
All right. I want to get through some of these others. You're going to show up in person on that one, right?
You had it via Zoom, Your Honor.
No, on that one, I'd really like you to appear in person if you can. It's going to take a long time, and I'd rather do it in person.
Okay, if you're asking me to be there, Judge, I'll be there.
What do you have? Do you have some conflict?
Just lots of stuff going on. It's a Monday. I got hearings this morning, afternoon. So if you need me there, Judge, I'll run home on my way back. I'm in the office now.
Can I have Ms. Turner come back and Ms. Moore? Listen, Ms. Moore and Ms. Turner, can you show up on this Concord versus Robinson at 1:30? Ms. Moore, you can appear by Zoom. Ms. Turner, you can appear by Zoom. I'll handle that one first and then take the Mount case right after that. Okay?
All right, so we're adjourning this one until the afternoon, Your Honor, right?
Just till 1:30. Ms. Moore, can you hear me?
Yes, yes.
Can you just show back up on Zoom at 1:30, please? I really appreciate your patience on this.
Okay, no problem. I'll be there.
Thank you very much. I'll see everybody here on that one at 1:30, then I'll do the mouth one. Credit acceptance versus Treasurer Crane, 2503129.
Good morning, Your Honor. Alexander Popov, appearing on behalf of plaintiff.
Mr. Popov, how are you? Ma'am, your name?
Treasurer Crane.
Okay, did you two talk at all, counsel?
We did, Judge. We have an agreement, if I can just place it on the record.
Okay, go ahead. Is it conditional dismissal or consent? Judge.
Consent judgment.
Okay, go ahead.
The total amount owed on the account includes the principal balance of $10,580.21 plus costs, $164.80, and a service fee of $43.65 for a grand total of $10,788.66. That judgment by consent shall enter against the defendant for that amount. The parties agreed to accept a reduced lump sum amount of $2,158 to settle the account. The settlement shall be paid on or before January 4th, 2026, and plaintiff will submit a satisfaction of judgment when the reduced settlement amount is paid in full. If the defendant fails to abide by the terms of this agreement, plaintiff will file a motion with the court to set aside the terms and pursue the regular course of collection on its judgment in its entirety. Judge,
Go ahead.
When we were in the breakout room, Ms. Crane did also give me consent to sign on her behalf as well.
Okay, ma'am, do you understand everything that Mr. Popov just said?
Yes.
So he tells me that you consent to a judgment in favor of the plaintiff and against yourself, the amount of $10,788.66, that you can pay this judgment in full on or before the 4th of January of 26 in the total amount of $2,158, in which case you're going to get a reduction of the amount owed by somewhere in the neighborhood of about $8,300 or so, $8,400. If you don't pay that by January 4th, then you're going to owe the full amount of $10,788.66. Do you understand and agree to those terms?
Yes.
Does Mr. Popov have your permission to sign your name to this proposed consent judgment?
Yes.
Do you have any questions for me at all, ma'am?
Nope. It was very simple. Thank you.
Have a great day. Thank you. Thank you,
You do
Mr.
the same.
Popov. Synchrony
Thank you, Judge.
Bank versus Michael Rhines, 2503178. Mr. Rhines, your name, sir?
Michael Rhines.
All right. Who is here for the plaintiff?
Veronica Lakriki for the plaintiff.
Okay, good morning to you.
Good morning.
So we are here today on the plaintiff's motion for summary disposition. Did you two talk at all, counsel?
We did not talk. However, a defendant has reached a settlement with my settlement team. I personally was not part of that settlement, but I do see the confirmation of settlement. He's already been making payments. And the only thing that my team did not do is send him the paperwork to sign in the form of a consent judgment. So I have already instructed them to do that. And because of that, I don't think my motion is necessary to proceed today. And I was going to request an adjournment instead, in hopes that the consent judgment will be in place before the next hearing date.
I'm going to adjourn this to October 20, I believe, Linda. Is that right?
Yes, Your Honor. How about 9 o'clock?
At 9 a.m. Parties reach tentative agreement. Sir, if you send that back, they're going to send it to me. I'm going to sign it. If they don't, I'm sorry, if you don't sign it and send it back, I'm going to just hear the motion for summary disposition on October the 20th at 9 o'clock. Do you understand all of that, sir?
Yes, but they never sent me anything to send.
Come up right here, sir. Good morning.
How you doing, ma'am?
Good. Are you Brian Battle?
Yes, ma'am.
And Mr. Battle, this is your initial appearance. Let me get it pulled up. In cause number 25 DCCR 1050. The computer knows it's Monday. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from July 10th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am.
You have. Did you hire someone?
No, ma'am.
Okay. So what I do, Mr. Battle, since you just got out of jail and made that bond, is I'm going to reset your case for about 30 days to give you some time to try to hire a lawyer. If you get a lawyer hired before the next court date, then bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so that I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk, she'll give you a reset notice. William Bonilla. Good morning, you're William Bonilla. And Mr. Bonilla, did you get a lawyer hired?
No, never.
Who'd you talk to?
I talked to Mr. Rojas and Miss Brittany Barnes, and I was trying to get in contact with this man as well.
Who's that?
Mr. James in Packard,
Uh-huh.
and I haven't necessarily got in contact with him.
Okay. So are you working?
Yes, ma'am.
Where are you working?
I work with Timber Industries.
Okay. So you need to get a lawyer hired. This is going to be your last reset. You were on bond and you got arrested for a new case already. So your bonds, and it could potentially be considered a little low for the fact that you were already on a felony bond. I want you to have an attorney hired before the next court date. Don't limit it to 3. Start calling today, talk to as many as possible, and figure out who you're going to hire, okay? Step in front of the clerk. Christopher Davis. Christopher Davis. Your proper name, please. Mr. Davis, did you get someone hired?
No, ma'am. I talked to some attorneys, but I can't afford an attorney. I wrote a letter.
Who'd you talk to?
I talked to, actually, Rifles. Anyway, Mr. Wilkerson Law Firm, I talked to Justin Gilmore.
Okay. Are you working?
The job is not started yet, but the habitat. It's coming up, but it hasn't come through the building 2 new houses.
All right. So I don't need to read your letter. I just need, since you did what I asked you to, I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. Don't just leave it all blank and put zeros. Put any bills you have, any income you might have, and then I'll take a look at it. If you step in front of the clerk over there, she'll give you that paperwork. Lacaria Kirkwood. Good morning. Are you Lacaria Kirkwood? And Ms. Kirkwood, this is your initial appearance and cause number 25 DCCR 0190. You're charged with the state jail felony offense of unauthorized use of a vehicle from January 8th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Ms. Kirkwood, is reset your case about 30 days to give you some time to try to hire somebody. If you get a lawyer hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of those that you've talked to and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you your reset notice. Mark Garcia. Good morning, sir. You're Mark Garcia?
Yes, ma'am.
And Mr. Garcia, did you get someone hired?
No, I didn't. I can't afford it. I just need a little more time to get the money together.
Well, who'd you talk to?
Just talked to like Sheriff and Alfred's, Wilkerson, Marcus Wilkerson. And then I talked to Willard, James Hall Jr.
Speak up, please. I'm
I
sorry.
talked to Willard, James Hall Jr. and Marcus Wilkerson, and then Leanne Johnson. I tried a couple ones, but I left some voicemails, but I haven't heard back yet.
Okay, so what I can do, Mr. Garcia, you've been coming for a few months. If you, since you did what I asked, you can fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. If you make sure you fill it out accurately and completely, don't just leave it all blank or put zeros. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. Step in front of the clerk and she'll give you that.
Take it to your seat, include everything in this section. If it doesn't apply in documentation, don't just leave it blank.
Drayden Rose. Good morning, you're Drayden Rose. And Mr. Rose, were you able to get someone hired?
No,
Did y'all talk to some lawyers?
yes, ma'am.
Who'd you talk to?
I talked to Corey Crenshaw in the cat law firm in Diffie Reynolds.
Okay, and where are you on being able to get someone hired? You weren't able, do you think, are you working?
No, I'm trying to find a job. I live in Oregon.
Okay, all right, so what I'm gonna do this morning, Mr. Rose, is have you fill out some paperwork to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. Don't just leave it all blank or anything like that. You're gonna swear under oath that it's all true and correct, and then I'll take a look at it. Step in front of the clerk over here and she'll give you that paperwork. Lance Charbino. Good morning. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino, did you get someone hired?
No, ma'am, but I have been speaking to him and I went and met up with a Pierce Rappin. He's spent $500 down. I got $2,700 saved up. And then also talked to Corey Crenshaw again and and didn't get off till 11 o'clock last night for work, and I got home and paperwork at home for Pierce, and I was gonna show it to you that I've already made a payment to him, but he wants that full $3,500 down before.
And what's his name again?
Pierce.
Pierce?
Yes, ma'am.
What's the last name?
Rappin.
Rappin?
Pierce A. Rappin.
R-A-P-I-N? Where is
Yes,
he?
ma'am. He's out of Lake Charles.
Okay, and he practices over here
Yes,
in
ma'am.
Texas?
Yes, ma'am.
So will you, you've been coming a few times, if I give you one more reset, you'll be able to get him or someone hired? All right, so this will be the last one. You need to get him or someone else hired before that next court date, okay? Thank you. Step in front of the clerk. Lisa Pratt. Lisa Pratt. On the name, please. Thank you.
No response, Ron?
Bond will be forfeited for non-appearance and reset at 100,000. Caitlin Talmore. Good morning, you're Caitlin Talmore. And Ms. Talmore, were you able to get a lawyer hired? All right, who'd you talk to?
I wasn't able to talk to anybody because at the moment I don't have a job. And I cannot.
Speak up.
I said I wasn't able to talk to anyone at the moment. I don't have a job. I can't.
Okay, but I told you last time to talk to some no matter what. Go talk to 3 lawyers, so at least you know what they charge. You can, right? Isn't that what we talked about?
Yes.
Okay. So where have you been trying to get a job?
If it was possible, yes. Yes, I am.
Okay, like where?
HEB, Burlington, I feel like applications to Walmart, Lowe's, I have a few, basically different places.
Yeah, okay. I'll look at something real quick. All right, so what I'm going to do, Ms. Talmore, is have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're going to swear under oath that everything contained in it is true and correct. If you'll step in front of the clerk down there, she'll give you that paperwork. Marquise Berry. Good morning, you're Marquise Berry. Speak up. And Miss Berry, were you able to get a lawyer hired? Right over now. Okay. So what this says is that you don't have any complications that would require you not to work with some certain parameters. So you're not on bed rest. For who? Have you tried?
I was working at before. I had stipulations and let me come do something that I had no stipulations.
Okay. All right. So I'm going to have you fill out some paperwork this morning, Ms. Berry, to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct. Step in front of the clerk down there. She'll give you that paperwork. Maria Garza.
Complete everything in this section. And if it doesn't find my notation, don't just leave it for you.
Good morning. Are you Maria Garza?
Yes.
And Ms. Garza, this is your initial appearance in cause number 25 DCCR 1008. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from June 15th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I was too bad. You had gave me, attorney Courtroom.
Right. And so while you're in custody, we automatically give you a court-appointed lawyer. But now that you've bonded out, I'm going to expect you to try to hire your own lawyer.
Okay.
So what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone.
Okay.
If you get someone hired before that next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone, if you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would have to go back to jail. Do you understand?
Yes.
Right, step in front of the clerk right here. She'll give you a reset. Just sign this first and then you can grab it on your way out. Janicia Leonard. Good morning, you're Janicia Leonard. And did you get someone hired?
No.
Who'd you talk to?
Brian, Lee Walker, Lorraine Burks, and I reached out to Crenshaw,
Uh-huh.
everybody just paid me $550,000 just to start with. And I haven't, well, I received 3 job offers, but background check, of course, I have 2 interviews today.
Okay. So thank you for doing everything that I asked you. I'm going to have you fill out some paperwork this morning, Ms. Leonard, to see if you qualify for a court-appointed lawyer. Obviously, if you do qualify and then you do get one of those jobs, things could change and you would need to hire your own lawyer. But for now, you've done everything I asked. So make sure you fill it out accurately and completely. You're going to swear under oath that everything's true and correct, okay? Step in front of the clerk. She'll give you that. See, Mr. Kyle Walker, you have Antonio Sanchez sentencing. Are you ready on that? And congratulations.
Can we step up and grab him real quick?
I'm sorry, Antonio Sanchez.
Antonio Sanchez.
Good morning. Good morning. You're Antonio Sanchez. And Mr. Sanchez was previously in court, entered a plea of guilty to the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle. And that's cause number 25 DCCR 0790. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
We have, Your Honor.
We have, Judge.
Any additions or corrections?
Not by the state judge.
Not by us, Judge.
All right, Mr. Sanchez, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do everything that you're supposed to on this probation, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, at the end, the case actually gets dismissed and you will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be found guilty. So you would become a convicted felon and you could go to prison for anywhere between 2 and up to 10 years. Do you understand?
Yes.
I'm handing you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. If you'll just have a seat here in the courtroom and watch for probation, she'll call you up when she's ready to go over your paperwork.
Yes,
All right, good luck to you, sir. Thank you, Mr. Walker.
Yeah.
Judge, I actually have one more.
Are you here for,
Aaron Shetley.
okay. I think I've got your dad down on that one, but
Yes,
you're here
ma'am.
for him.
He
All
was
right.
in Liberty and
Gotcha.
Chambers.
Aaron Chetley, 24 DCCR 0776. This is Miss Malfino's case, Aaron Shetley. Good morning, sir. You're Aaron Shetley. And Mr. Shetley in 24 DCCR 0776 is charged with assault, family violence by impeding breath or circulation. And what is the announcement?
Judge, we just need a reset. We're still going through the discovery in the case. So if we can just have a little bit of time to finish that.
It looks like you guys were hired. Yeah, just hired August 20th, it looks like. So, okay.
For the next topic, for sure. I've already sent him everything. I want to make sure he feels like he's got it.
Okay, I'll just do a normal reset. Mr. Shetley, make sure you stay in touch with your attorneys and they'll let you know when you need to be back. Y'all can also visit about all the information that they've received and what any options are. All right. Thank you. You're free to go. Thank you, Mr. Walker.
Max, you good?
Yes, sir. Is Mr. Comerford, is there a Mr. Comerford here? Oh, okay. Ms. Malfino, on Frank Collins, that is Mr. Gert's case.
I don't have any update.
I think he said they're waiting on his sentencing. He sent an email. He also let me know, I think it's past the time for any objections to the PSI, so it shouldn't be hopefully much longer.
Okay, I think that's kind of where we were last time, so hopefully
Yeah.
we should get it disposed.
So what I'll do, maybe I'll just do 45 days. If something happens before then, y'all can always bump something up and let me know. So is Frank Collins here? Mr. Collins, thank you for being here. We're going to reset your case. Make sure you stay in touch with Mr. Gertz. He'll let you know what's going on. And then we've got John Jackson. That's Mr. Smith's case. And Mr. Gertz is announcing ready for trial next week on Mr. Jackson's case.
Okay.
He's not here. He's out of town. And what's your announcement?
That's right.
Okay. Yeah, I will number the case. If there's anything that happens this week, if y'all will let me know. I think he'll be back tomorrow. If something changes, just let me know.
The kids guy's not changing.
Okay. John Jackson. He did? Oh, okay. Okay, never mind. Don't worry about it.
Post Judge,
Sure.
I have one case, Mr. Hart, and I've talked to Mr. Nichols, and I believe that he wants a little more time to talk to the victim. He and I are in negotiation about what we're going to do.
Okay.
That's correct.
Jimmy Hart.
He's here, Judge.
All right, I'll just do a normal reset. Mr. Hart, stay in touch with Mr. Parker so that once he visits more with Mr. Nichols, you guys can visit about your case and we'll get an announcement. Thank you.
Thank you, Judge. Thank you, Judge.
Thank you. Mr. Rojas, you have Juan Martinez Rodriguez. It's 25 DCCR 0017.
Speaks very little English, Judge. I'll translate with the court's permission.
Okay, thank you, Mr. Rojas. Sir, are you Juan Martinez Rodriguez?
Yes.
And Mr. Rodriguez, and cause number 25 DCCR 0017, you're charged with a third-degree felony offense of theft of property, and that's from September 12th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation, which means if you successfully complete that probation, you would not have a felony conviction on your record. You have every right to reject that offer. I just want to make sure that you understand what the possible consequences are if you're found guilty and what your options are if you wanted to plead guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
All right, I'll get it set for trial. I want to also make sure, Mr. Rodriguez, that you understand that after today, I will not accept this plea agreement. Once your case is on the trial docket, if you change your mind, you can enter a plea to something different or go to trial and have a jury decide. You understand?
Yes.
And you're appointed, correct?
No.
Okay. All right, then Mr. Rojas will begin preparation for trial. Thank you. And you also have Eliza Riley.
Yes, ma'am.
Eliza Riley.
He's checking off. But I'm not gonna set a trial.
Good morning, sir. You're Eliza Riley. And Mr. Riley, in cause number 25 DCCR 0380, you're charged with the third-degree felony offense of deadly conduct discharging a firearm. Are you sick? Are you sick currently? I can't hear you. Are you sick?
No.
Then pull that down so I can see your face. Stand up. So you're charged with the third-degree felony offense of deadly conduct discharging a firearm, and that's from December 21st of 2024. Your indictment alleges that you were previously convicted of possession of a controlled substance, third-degree felony in 2011. And what that means is if you go to trial in this case and you're found guilty and that prior conviction is true, the range of punishments between 2 years and up to 20 years in prison. Do you understand? Speak up. And I have here on.
I know there's a rejection that's been signed in this case. I'm asking we don't set this case for trial yet. There's a witness statement that contradicts a lot of the facts that are alleged. I need to look into that before we set this for trial.
Okay, so why don't I just delete that and let's reset it one more time and for y'all to do that. So Mr. Riley, before I set your case for trial, it sounds like there's some more discovery and evidence that needs to be looked at. So I'm going to do one more reset for everybody to look at all of that. And when we come back, if there's still a rejection and we need to go to trial, then we'll get it set at that point. Okay? Stay in touch with Mr. Rojas. He will let you know when you need to come back. You're free to go. Thank you. Mr. Samuel?
Yes.
On Julia Schultz?
Yes, Your Honor.
Good morning.
Good morning, Mr. President.
All right, you're Julia Schultz, and this is 24 DCCR 2290. What is the announcement?
Judge, if we may just have one final reset, I have no reason to believe that we don't have the case disposed of. There's a hearing tomorrow down the hall family court. We'll get some finalized paperwork signed, et cetera, that I need to make the offer of extended, but I don't have any reason to believe that we're not going to work.
That's
Okay.
my understanding.
Obviously, it's been going on for quite some time, so
Yes.
this will be the last reset. Something needs to get worked out before that, by that next court date.
Will do.
Okay?
Okay.
Stay in touch with Mr. Samuel. He'll let you know when you need to be back.
Thank you.
Thank you. Mr. Comerford? Good morning. Are you ready or do you need me to hold your case for now?
I'm not ready yet.
Okay, I'll hold it.
Thank you.
Okay, is Maverick Neal here? Come up, sir. Mr. Nichols, this is,
I spoke with Mr. Joel last week, Your Honor.
we did too.
Need to review the PSI.
Yes, Your Honor.
Yes, Your Honor. Is there any reason not to go forward with sentence today?
No, Your Honor.
No, Your Honor. We have 82 days of jail time credit. Does that sound right to everybody?
That's correct.
Sounds right to me, Your Honor. Mr. Harris, on behalf of the state.
Your Honor, BCI did the laboratory work for the record. We aren't requesting any reimbursement. It looks like residential, well, actually CBCF is the recommendation of probation. I think that that is in order. Would also request sober living once she's completed CBCF.
Officer Rose, what's the recommendation of probation in the case?
Your Honor, the recommendation is that the defendant complete the Monday program. They have a big focus on mental health, and I think it'll benefit the defendant as well as transitioning to a sober living after with the monitor for a period of time.
Mr. Riccello?
Thank you, Your Honor. My client, just in discussions today after reviewing the PSI, has certainly requested to go back into recovery defined. I think she was having some success there before her mishap in August, where she was taken into custody. The concern I know is, in discussing the recommendation with her this morning, is that she still has quite a bit of her personal property and items there still at recovery defined. I don't know how to go about getting those items transported from that location to the Monday program. Presumably she will not be transported today to the Monday, so there may be some delay. I don't know if the court has any input or could provide some insight as to how to go about doing that. Ultimately, she would like to go back to the recovery defined. Again, having some success there, I feel like programming was having some impact for her. So we're asking the court to consider allowing her to start her probationary term with a term at the recovery defined house.
Ms. Lewis, what do you, I'm sorry, anything else, Mr. Riccello?
I was going to say, I think Ms. Lewis would like to address the court.
All right, what do you want to tell me, Ms. Lewis?
Well, I mean, this is something new, so taking into consideration doing the Monday program, but yeah, just having my belongings either transferred over or just do the Monday program and then be on a probationary period and don't have to do recovery defined. But as long as my belongings are back with me, I'm fine.
Well, I do think that sending you back just to recovery defined without the additional support, Ms. Lewis, is setting you up for failure. I don't think that is a intensive enough program for you. I am going to place you on 3 years of basic probation. I'm going to impose upon you the standard rules of probation and delegate to your community control officer the ability to make special or additional conditions as they see fit. At this point, it's going to be a special term of your probation that you enter into and successfully complete the Monday program. Plus, I'm going to put you on 45 days of electronically monitored supervision upon your release into an acceptable residence. So you're going to be in the Monday program for a while. And when you get out, or when you're really ready to get out, that's when we put together a transition plan. If the plan is, hey, I got a good place to go with all of my stuff, we'll consider that. If you don't have a good plan and a good place to go, maybe we send you back to recovery defined or one of those sorts of places. I am going to put my case manager, Ms. Wilkerson, on the issue of your personal property. She'll reach out to Ms. Wright or whoever we need to do at recovery defined to make sure that your stuff is secure somewhere until you get out of the Monday program.
Can it be, do I wear my normal clothes there, right? Like my clothes and stuff can be dropped off to the Monday program, right?
I would assume so, Ms. Lewis, but I don't really know how that works. So between Officer Rose and Ms. Wilkerson, that is a detail that we can get sorted out.
Okay.
I'm not going to impose a fine. I am going to impose the costs upon you if you violate the terms of your supervision or you leave the state without permission. I can send you up to the maximum penalty in the case, which is 18 months in prison, plus an optional period of post-release control of up to 2 years. Anything else?
No, Your Honor, thank you.
All right, finally, Ms. Lewis, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you at no charge. Officer Rose, if you could, talk to Ms. Lewis about the stuff, reach out to Ms. Wilkerson if we need to, or to the people at the facility. And, I mean, we can figure something out.
Yeah.
Okay? All right. Good luck to you, Ms. Lewis.
Thank you.
I will come to the jail tomorrow to see, and I'll bring this one person with me so we can discuss this by yourself. Okay.
Thank you.
Yep.
All right, we are in.
Good morning, you're Maverick Neal. And Mr. Neal, your attorney, Mr. Doyle, is out with some health issues and will be for some time. He's asked that I reset your case. I want to ask you if that's what you want me to do, or if you would like me to consider if you could qualify for a court-appointed lawyer so we can get your case moving. You can wait. So what did he say? I know, but time-wise,
Surgery's in November.
that's what,
I forget how long.
I know.
Yeah, but something it's major.
Yeah, that's what I'm concerned about. Yeah. Okay, so Mr. Neal, I'm going to reset your case until the first of the year. And so you need to stay in touch with Mr. Doyle. You need to be talking to him, get in touch with him, continuing. If y'all have a contract, pay him whatever you need to do, and then we'll see where everybody is in January. If at that point he's unable to be back, then it will be time for you to either hire another lawyer possibly, or us look at a court appointed, okay? Okay, you're free to go. You're free to go, sir. Thank you. See, is Mr. Flory here? Mr. Flory? Mr. Frazier? Ms. Hawkins? Good morning, Ms. Hawkins. On Devin Spites?
Can we hold on that, Judge? He'll be here in about 10 minutes.
Sure. Did I see Mr. Jeffries? Mr. Kimmer, Mr. Rivers. Ms. Norman, are you ready on Charles Guidry?
Judge, we are ready to make some sort of announcement.
All right.
I see Mr. Coleman here this morning. I think he's getting ready for a trial.
I think so. I'm sure somebody will step in. Charles Guidry? Good morning.
Good morning. How are you?
Good. How about you?
It's Monday.
It is Monday, and it's a full moon.
A long-lasting full moon.
Good morning. You're Charles Guidry, and Mr. Guidry is charged with theft of property in cause number 23-41646. And Ms. Norman, where are y'all on this?
So, Judge, we have all the discovery. We have an offer. There's some restitution involved and some other minor things that I'd like to be able to talk to Mr. Coleman about to try to see if we can resolve this without me placing it on the trial docket.
Okay.
But I'm certain it's gonna be a plea, so if we could just reset it for a plea, and that'll give me time to talk to Mr. Coleman.
Sure. And it looks like you were just.
Mr. Smith, but.
Yeah, maybe he'll work on that with you
It's
this
all
morning.
relative.
Whoever thought somebody would say that about you, Mr. Smith? Just kidding.
We go way back.
All right, so, and it looks like you were just hired in August. So we'll just do a normal reset to give you time to talk to Mr. Coleman and see if y'all can get that worked out. Mr. Guidry, stay in touch with Ms. Norman. Once she gets all that information, you guys can go over and see what the outcome will be, and we'll get it taken care of at the next court date. All right, you're free to go. Thank you. Let's see, Matuska, Pageant. Let's see, is there a Mr. Peraza? Good morning, Mr. Peraza, on Juan Martinez.
He is president of council, Your Honor. May we hold for a second?
Sure. Yes, sir. Everybody wants to talk to the state this morning while they're busy. I thought I saw Mr. Roebuck. Doesn't Mr. Roebuck come in? Oh, they're down there doing that first. Okay. No paperwork coming through. Is that on the docket? Is it just a? Thank you. Thank you, Mr. Lewis. And is your client here?
He is.
Mr. Francis, Ray Francis? Mr. Francis, I'm signing the dismissal in your case now. You're free to go, sir. And let's see, Mr. Lewis, you've got Deshauna Bass.
Yes, ma'am. We can hold on that one. Mr. Nichols was reaching out to Mr. Coleman about that.
Okay, I'll hold it. And your client's here?
She is here.
Okay, I'll hold, thank you. So did I see Ryan Matuska? Yeah, I did look at that. I said your name and you walked in the door, Mr. Matuska. On Michael Brasher, 23 DCCR 0944.
Sorry, Judge.
Good morning. That's okay. You got plenty going on between the two courts to share.
Yeah, somewhat calm over there.
No, you just messed that. You better knock on all this wood. You just messed it up. When I hear them complaining later, I'm going to tell them it was all you.
What do you do?
He said it was
I said
calm
that
next
word.
door. He did.
Christopher Davis. Christopher Davis.
Have you seen Mr. Brasher?
Call yesterday or Friday.
All right, his bond will be forfeited for non-appearance, reset at 100,000. If you can get in touch with them and get them here, then obviously I'll reconsider that.
And you're already driving corpus, maybe that's the issue.
Okay.
I'll call him too.
All right, thank you.
Yeah.
James Rucker, Mr. Galmore, I'm signing those. Oh, never mind. I read that wrong. I was about to say I was signing dismissals. Don't you wish?
Rejection.
That would be the opposite of
Maybe that's
that. Okay, so we're finally there in this one. Good. All right, sir, you're James Rucker.
Yes, ma'am.
And Mr. Rucker, in cause number 24, DCCR 1348, is charged with violations relating to hazardous waste and it's a third.
Mark Garcia.
The punishment range is that of a third-degree felony in that one, which is between, if you're found guilty, between 2 years and up to 10 years in prison. Do you understand? And then in cause number 24, DCCR 1349, you're charged with theft of property. Which is a state jail felony, and that's from May 18th of 2022. And then what that means is if you get found guilty in that case, the range of punishments between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
In each of these cases, I have plea bargain rejections here with your signature on them and Mr. Galmore's that shows that the district attorney's office has made offers if you wanted to enter a plea of guilty in your cases. In the violation of relating to hazardous waste. They've offered, it looks like, is that a 6?
Oh, no, I didn't put the year, sorry, Judge. It was short.
Talmore?
The deal was for a short term of deferred.
So it's for a deferred probation that would be up to me, and I guess, which is obviously you've gone over with Mr. Galmore, type of probation where you don't have a felony conviction on your record. And then is it the same in the other case? So you would be, if you wanted to plead guilty, it would be deferred probations in each of those cases with the term and how long that probation is up to me with input from everyone, of course. You have every right to reject those offers and have both of your cases set for trial. I do want to make sure you understand that what your possible consequences are if you go to trial, what your options are if you wanted to enter into those agreements. And do you understand all of that? And do you want to reject those agreements and have your case set, both cases set for trial? All right. And is there any reason, I mean, obviously, I can't imagine that the offer would get better. Ms. Malfino?
It's a Mr. Shearer's case, Judge. I don't have any reason to believe that that offer would change. I know they've discussed it for quite some time. I want to
Yes.
make sure it's on the trial docket that hits the peer review.
So I do typically make sure, unless there is new evidence that comes up that either Mr. Galmore or Mr. Shearer does not know about, or something has changed, I will not accept these plea agreements after today. And so if you change your mind later and want to enter a plea of guilty, it would be to some other plea agreement or open to the court or something like that. Do you understand?
Judge, just for the court's perspective, this case had a restitution in the amount of approximately $100,000. That's been reduced to approximately $13,000 now that those financials have been sorted correctly.
Okay.
I believe this is a situation where it'll either require trial or it would be dismissed for restitution.
Okay, so not a restitution paid out over probation. Okay, all right, then, obviously, if that happens before, then the cases get dismissed, and that's another way for them to get off the trial docket, but other than that, we'll let a jury decide. All right, you're free to go. I'll set it on the trial docket. Thank you.
Drayton Rose?
Is that Rose? Is it called Rose?
Over there. It's a different one. James Rhodes for you.
I'm sorry.
James Rhodes.
Judge, may I just put something on the record?
Yeah, do you have a dismissal on that?
I don't.
Oh, not yet. Okay. Is he here?
No, he's late, but I found out they're gonna dismiss today.
Okay.
Judge, I just would like to put on the record, if I may, Mr. Rhodes is enrolled and doing very well in the Veterans Treatment Court. That docket will be in 2 weeks. I'm going to go ahead and dismiss the case today. He has progressed nicely through that program. Just wanted to put that on the record due to the nature of the case.
Sure.
I don't have any information indicating there's been any issues between he and the complainant in this case. So
okay,
with the court's permission, that way he can try to get his job back now with the dismissal, with the understanding that if he doesn't complete the case,
okay, thank you. I'll sign it when it comes through. You can go ahead and let him know if he's on his way that he doesn't need to come
I
in.
will. Thank you, Judge.
You got Norbert Freelow Jr.,
Yes.
25 DCCR 0366. Good morning, sir. You're Norbert Freelow Jr. And Mr. Freelow is charged with murder, and Mr. Galmore, Mr. Nichols, what's the announcement?
Judge, I don't think we're ready to set this for trial yet. I know it seems like every hearing I tell you there's stuff we need to investigate to find out, and there is still in this case that there's a potential witness who has given unsworn statements that is basically blown off appointments to give a sworn statement, and we need to run her down.
That's what we were going to do last time.
And they made appointments and she didn't show up.
Well, if we're talking about that one witness, she did meet with the investigators between.
Okay.
But there's also a new witness, another witness.
Okay.
And possibly some video footage that was deleted that I believe that Port Arthur Police Department is trying to get their hands on.
I need to check the status of the subpoena for that video. We need a little more time to it.
Okay. All right. We'll just do a normal reset. Y'all can work on that. We'll see where we are at the next court date. Mr. Freelow, make sure you stay in touch with, did you have something
I
else?
could, yes, Judge. I don't have a motion necessarily on file, but Mr. Freelow currently is on house arrest with a GPS device. His wife has recently been unable to return to work to the federal prison, so their income is limited. He's trying to find a job. It's been difficult, obviously, with thing hanging off of your ankle and whatnot. So we were asking the court if the court would consider removing him from house arrest and GPS requirement.
No to both of those things, but potentially to, the GPS is going to remain on. I would consider. Mr. Nichols, what's your position with regard to him looking for work and getting a job?
I'm in favor of that, Judge. As long, but I agree with the court. I think the monitoring needs to stay in.
For now, at least,
Monitoring moving from house arrest?
Mhm.
Okay.
Yeah. Wear long pants and cover it up, whatever you need to do. But at this point, I'm not willing to do that based on obviously the nature of the offense. And so if you do this, Mr. Galmore, if you'll just send maybe a memo over and copy Mr. Nichols on it so that I have a paper trail to say that you asked me and that I granted that part of it, and I'll just sign off on a memo. It doesn't need to be a motion.
We'll do
But
that.
that'll just remind me to get it in the file so that it's clear. Also, we can send that to whoever has his GPS monitoring device so they know it's just for work related purposes. You can go find a job, go to work, things like that. But it's not just a full on go do whatever you want kind of
Well, Judge,
release.
actually, that's currently the status. He is allowed to leave only for work purposes. currently.
Okay.
But because his wife is unable to work, her medical conditions made it much more difficult for them. So if the court would still consider just removing him from house arrest and keep the GPS, that would probably help a lot with other life's necessities.
Okay. I know you've asked for him to drive her to this. There's been
Yeah, he had to take
doctors
him to the
issues.
airport the other day. But I mean, obviously in life, a lot of things like that pop up regularly. And if he's going to wear a GPS device, the court will always know where he's at. That's important. But removing him from house arrest would be probably a big help.
Mr. Nichols?
Hard for me to really argue with that reasoning, Your Honor.
Okay, so I am going to require for you to remain in Jefferson County without permission. So if something happens, like the other day with the trip to airport or whatever, get with Mr. Galmore, he'll send me something, I'll approve or not approve. In Jefferson County, do what you need to live your life. I don't want, that doesn't include going to bars or going out at night
Maybe a
or.
curfew is appropriate, Your Honor, unless,
Yeah, that would be,
if he ends up with a night job, obviously that's different, but.
so let's do this for now. Let's make I'll release the house arrest, remain in Jefferson County with the curfew 8 p.m. to 6 a.m. If you get a job that interferes with, just get with Mr. Galmore and get those hours, whatever the job is, and we'll work around that. But primarily, I want you doing necessities away from your home, and that's it at this point, okay? All right,
Judge.
thank you.
Thank you, Your Honor.
One more. Brandon
Yes,
Broussard.
Brandon Broussard. Yes, ma'am. Okay. Good morning, sir. You're Brandon Broussard. And this is 24 DCCR 1150. Mr. Broussard's charged with aggravated assault causing serious bodily injury. Mr. Galmore, what is the announcement?
Judge, we're asking for another announcement day just to continue to go over any of the evidence and getting with the state, see if we can resolve this without.
All right, looks like you've been on since June. I'll do one more. Mr. Broussard, you need to make sure, stay in touch with Mr. Galmore. Y'all go over everything. Because at that next court date, we need to get an announcement whether or not this is going to be a trial or if it's going to get worked out, okay? All right, we'll see you at the next court date.
Thank you, Judge. That's all I have.
Thank you. This is Mr. Frazier. I guess just Mr. Roebuck knows, I guess this is getting dismissed and doesn't need to come back down.
They went down the hall and took care of the
Okay.
motion, Your Honor.
Okay, I'm signing that dismissal now. Mr. Jeffries, you have Stephen Hayes.
Yes.
Mr. Hoffpower. Morning. How are you? It's Monday.
Yes, ma'am. That is fact.
Morning. All right, good morning, sir. You're Stephen Hayes. And Mr. Hayes's cases are set for trial to begin with jury selection next Monday. What is the announcement?
State your, ready?
All right, any negotiations or anything we need to talk about that anything's changed? It will very likely be the number one case due to the nature of the offense and the age. And so if anything changes with any negotiations, really need to know by tomorrow when I set that trial docket tomorrow after docket. Stay in touch with Mr. Jeffries, and if so that we know if anything changes, we'll get that taken care of this week. If not, we'll see y'all next Monday.
Yes, sure.
All right, free to go. Thank you. Where am I? See, Mr. Comerford, on Ronnie Oliphant.
Yes.
And this is Mr. Coleman's case. Morning.
Good morning.
Good morning, sir. You are Ronnie Oliphant. And in 25 DCCR 0379, Mr. Oliphant is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
We were just asking for another reset date so we can have more time to investigate.
Any issues that you see notated? All right, looks like you guys were hired at the end of July. I'll reset it another time to give you some time to try to get all that discovery and evidence taken care of. Mr. Oliphant, make sure you stay in touch with your attorney so you guys can go over everything, what your options are, and we'll see if we can get an announcement by next court date. All right, you're free to go. Thank you.
Simon Goddard. Gilbert.
Mm-mm. Yeah, I don't see him on the docket for some reason. If you'll just check with Ms. Holmes.
What's your name?
Simon Goddard. G-O-B-E-R-T.
Huh? Oh, where?
Is it on there?
Oh, are you here for Mr. Flory? We have Mr. Flory listed.
Oh, it's me. My office did file notice of appearance.
Oh, maybe
Yeah, it's on the docket. It just has a different name. Let me look here. Yeah, thank you. So do we need to change you to
Yes.
primary? Okay, Simon Gobert.
I apologize.
Good morning, sir. You're Simon Gobert. And in 24 DCCR 0512, Mr. Gobert is charged with the second degree felony offense of attempt to commit sexual performance by a child. What is the announcement?
Defense needs more time to review any potential plea offer.
We've given an offer, Your Honor. He's got to discuss it with his time.
Okay.
So I believe one more reset.
One more should be good because it looks like you were hired, this was from June. So yeah, this will be the last reset. Make sure you make an appointment, go visit with your attorney. So you know all your options. And when you come back, it'll either be taken care of with a plea or moved to the trial docket with a rejection. Okay. All right. You're free to go. Thank you.
Thank you.
Yes, ma'am. Let's see. Let me find you on here again.
She's on the last page.
Okay. Did you just say the last page?
Maybe it's page 5. What's the?
Oh, I'm looking at, sorry. Okay, here we go. Ms. Hawkins on Devin Spites. Good morning, you're Devin Spites. And in cause number 25, DCCR 0023, Mr. Spites is charged with theft of property. And what is the announcement?
And Judge, we had one last outstanding piece of discovery that was received this morning.
Okay,
So if you can have some time to review it.
all
I'll
right.
be sure to visit. I think there was just a miscommunication on that thumb drive, so we gave her a copy this morning.
Okay.
While she was already here, since she made the drive, and we'll be sure to talk about it before next day.
Okay, so Mr. Spites, make sure you stay in touch with your attorney so that before that next court date, y'all can go over all of the evidence that she's received in discovery. And we need to get an announcement at that next court date.
Yes.
All right? All right, you're free to go. Thank you.
Thank you, Judge.
Mm-hmm. Sure. Let me get to it. Juan Martinez, cause number 25, DCCR 0401.
Your Honor, he is a Spanish speaker. If I may translate for him.
Yes, sir.
With permission.
Yes, thank you, Mr.
Thank you.
Peraza. And sir, you Juan Martinez?
Yes, ma'am.
And Mr. Martinez is charged with assault of a peace officer from March 23rd, 2025. And what is the announcement?
Judge, on this one, we would ask for a reset. Spoke to Mr. Peraza this morning, and I want to go back and look at the body cam video.
Okay. Okay, so I'll do just a normal reset, which is about 30 days.
Thank you, Judge.
And that'll give Mr. Smith to go through that, get back with you. And Mr. Martinez, make sure you stay in touch with Mr. Peraza. So you guys can go over everything that he receives and know what your options are when we come back. Okay?
Yes, Judge.
All right, thank you. You're free to go.
I'll see you. Thanks a lot. Appreciate it.
See. So there. Mr. Paget, looks like you have Catherine Castillo.
I do, Your Honor. So Phillips case.
2 cases. Good morning.
How are you?
Good. How about you?
Excellent. Ms. Castillo, sorry, I didn't see you up on
Good morning. You are Catherine Castillo, and Ms. Castillo has two cases. She's assault of a peace officer and then also driving while intoxicated, third or more. And what is the announcement?
Your Honor, we need 30 days. I've received all the discovery. We're going to review the video evidence. I have an offer now. I'm going to relay that to her. We'll meet before we come back, and the case will be disposed of on that day.
Okay, this will be the last for an announcement. Ms.
Absolutely.
Castillo, make sure you get with Mr. Pageant. Now that he has everything, you guys can go over all that discovery, see what your options are, and we'll take care of your case at the next court date. Okay, you're free to go. Thank you.
Thank you, Your
Mr. Pageant.
May I be excused?
Yes, sir.
Thank you. Thanks for
Yeah. Mr. Frazier, you've got Edwinia Johnson, so sentencing.
Yes, Your Honor.
Good morning. You're Edwinia Johnson? And Ms. Johnson was previously in court, entered pleas of guilty in all three of her cases. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor, Mr.
Are there any additions or corrections?
I'd just like to address one thing that Mr. Smith had a problem with. It's kind of a law of parties thing on the forgery, I think. And I'll ask my client to clear it up. Now, you're working for a home health care agency, is that correct? And
Answer yes or no, please.
and your client at the time had asked you to dispose of some personal banking checks, is that right?
Yes, and I took them. I misspoke. I meant to say I took the checks, and I knew that Adrian Hayward was going to cash them, so I'm just as guilty as him.
So, and she said in here that she's the one who took them.
Yeah.
So I'm okay with that.
Brought it up and
Okay.
I had an issue about culpability.
I appreciate that. Yeah, I
And,
agree.
they've never caught AJ.
No, I've been hearing that he's incarcerated, but I haven't.
Okay. Any other issues?
No.
So I would like to know, just so that I know what, if any, conditions, what is the status of children? Where are they? Who are they with?
They're in foster care now. They wanted me to Judge Simpson, I think this is his name. He wanted the restrictions of the probation so he'll know how to move forward. But I went to court the 16th for them, and they was trying to dismiss them, but I didn't have paperwork on probation.
Okay. What?
Speaking of Deborah's story, that typically, as a condition of the criminal case, sometimes they put some of the won't abandon and get some of the CPS rules. I didn't see that.
Well, I guess I want to know what the status of, is CPS still involved? Is there a plan in place right now, an emergency?
I spoke with the CPS caseworker and they wanted to know how these criminal cases were going to resolve. The plan's always been reunification. She's done real well with them, according to her, the caseworker.
So I guess what I'm going to need is, or probation's going to need is, my ruling's going to be that there's no unsupervised visitation unless she's followed through with all of the CPS plan. And so, and that's pretty much what the PSI says, is that their recommendation is no unsupervised contact without authorization from CPS. So if you're doing everything you're supposed to with CPS, and
We can go talk to Judge Shelton maybe, or no, is this is fine?
no, I mean, that's as long as but she's going to have to give her probation officer documentation from CPS. So you can work that out with your probation officer. So mine's going to be no unsupervised unless, and then if probation gets that information and she's doing her safety kind of be the ones that dictate that. Johnson, in cause number 24 DCCR 2151, I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings in that case for a period of 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 24, DCCR 2152, also find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. You're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. And then finally, in cause number 24, DCCR 2153, find sufficient evidence to find you guilty. However, I'm again going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. There is not a fine in that case. And again, you're ordered to follow all of the rules and conditions of probation. One of the rules and conditions is that you have no unsupervised contact with any child, including your own, under the age of 18, unless CPS says that that's part of the plan and that's where they're working. And once they do that, if they do, you have to get that information to probation. So you can't just say, okay, CPS let me do it and I'm going to start seeing them unsupervised, because we won't know that you have that permission from them. Does that make sense?
Yes, ma'am.
So you've got to make sure and go talk to your probation officer, make sure they know everything that's going on. And so part of your probation is that you are required to comply with all the conditions that CPS is imposing. So if there's still any classes you have to do, whatever it is, that's now also part of your probation. Does that make sense? So if you do everything that you're supposed to while you're on these probations, then this is an excellent opportunity, because you don't have the felony convictions on your record. And at the end of the probation, if you do everything that you're supposed to, then the cases will actually be dismissed and you'll never be a convicted felon. The other side to that, though, is that if you violate any condition of probation, you can be brought back into court. You can be found guilty of each of the offenses. In that forgery case, you could be sentenced between 2 years and up to 10 years. And in those injury to a child cases, you could get up to 2 years in a state jail prison. Do you understand? In all of those cases, I'm handing you the trial court certifications that shows that these were agreements that I followed. And so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over all of your paperwork. All right. Good luck to you, ma'am. Thank you, Mr. Frazier.
Thank you.
Mr. Burbank, you have John Martin. John Martin. Morning. Huh? Good morning, sir. You're John Martin.
Yes, ma'am.
And Mr. Martin is charged in cause number 25 DCCR 0583 with injury to a child, elderly, or disabled individual. And Mr. Burbank, what is the announcement?
I believe the state and I are looking for some CPS records.
I don't see that there's been an order for those yet.
There hasn't, Judge. I'll get one filed. I needed to talk to Mr. Burbank to see if he already has it. He does not, so I'll be sure.
Okay, yeah, let's get that done quick because it takes a while, it seems like, on some of those. I'll sign that order as soon as it comes through. Let's go ahead and just do a 60-day reset because obviously it'll take a little time once I sign that for those to come in, but hopefully they'll come
They
in.
may have them over on the civil side.
Okay, all right. Yeah, if we can get
I'll
on
check
that way,
there, Judge.
that'd be
If
great.
not, I'll reach out to Miss Adams. She
Okay.
usually gets.
She is. Thank you. All right, Mr. Martin, stay in touch with Mr. Burbank. He'll let you know when you need to be back. You're free to go, sir. Yes, thank you. Ms. Holmes, you have TJ Landry. Good morning. How are you?
I'm gonna have to email both attachment.
Okay. Good morning, sir. Are you TJ Landry? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Landry, in cause number 24, DCCR 0165, you're charged with the state jail felony offense of theft from a person from December 9th of 2023. And how do you plead to that charge?
Yeah, no.
You either did it or you didn't do it. Are you guilty or not guilty?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak out loud, please. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
It looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
And is there any restitution?
No, the shoes were recovered that day.
Okay. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Landry is not
No,
competent?
Your Honor.
And Ms. Malfino, with regard to waiving pre-sentence report, is there any issues with regard to history I need to?
No, Your Honor, it looks like there may be some misdemeanor contact, but he has no felony history. I have no.
All right, so what I'm going to do, Mr. Landry, is waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty of the offense and you could be sentenced to the state jail prison for up to 2 years. Do you understand?
Yes, ma'am.
All right, I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. In just a few minutes, probation's going to call you up to go over your paperwork. She's sitting at that desk right there, so watch for her to call your name, okay?
Yes, ma'am.
Good luck to you, sir. Yes.
Sorry to interrupt.
Hang on.
Just, since we're waiving the PSI, may I ask to request of the court that one, he be trespassing from Parkdale Mall and that he not be allowed to have any contact with a Jalen Nixon or Reginald Hillary.
All right, so I'm going to order as a condition of your probation, Mr. Landry, that you are not allowed to go on the premises of Parkdale Mall. That'll be a part of your probation. Also, you're to have no contact or communication with Jalen Nixon and tell me the other name. Reginald Guillory. So that means in person, y'all can't hang out, but it also means any other way. You can't send messages, you can't Snapchat or DM or anything like that. You go live your life and whatever they do, they need to live theirs. Make sense? All right, you can have a seat. Thank you, Ms. Malfino. And then Ms. Holmes, you have Edmund Latulas. Edmund A, I'm sorry, I do that every time. Oh, I don't see her, so.
We didn't pick one.
Okay, I'll recall her as soon as she's ready. Mr. Lewis, are you still working on Deshauna Bass? Oh, okay, hold on, let me, y'all can come on up. Okay, we're going on a lesser. And this is Mr. Coleman's on Deshauna Bass. Good morning, you're Deshauna Bass? And will she waive the formal reading of the indictment?
She does, she does.
And Ms. Bass, in cause number 24 DCCR 2316, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault from October 27th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Bass is not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings and place you on probation for a period of 2 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a conviction on your record. And at the end of the probation period, if you successfully complete it, the case is actually dismissed. You'll never have a conviction. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court, found guilty of the offense, and sent to the Jefferson County Jail for a period of up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation is going to call you up in a few minutes when she's ready to go over your paperwork. So she's at that desk right there, so be watching for her to call you up, okay? Good luck to you, ma'am. Thank you.
Thank you.
Thank you.
And your signature's not on that. Yes, ma'am. It's like it doesn't matter if it's long or short. It's always the same. Mr. Rennick was just here.
Please give his client, Judge.
That's why she's not asking. Her. Trying to figure out one
Let's see, Ms. Holmes on Edmund A. Latulis, I'm ready on that. Good morning, ma'am. You're Edmund A. Latulis. And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Latulis, in cause number 24, DCCR 2057, you're charged with the state jail felony offense of abandoning or endangering a child, and that is from June 14th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? Speak up, please. And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $300 fine. You would be required to follow all of the rules and conditions of probation, including any referrals for any type of emotional support or counseling that you need. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation? Mr. Frazier, can you hold it down, please? That your plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number one.
No objection.
It's admitted. Is there any evidence that Ms. Latulis is not
No,
competent?
Your Honor.
And
Judge,
do we need to get a PSI just so we know what all needs to, I think so too. All right, ma'am, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there, okay? All right, we'll see y'all back at sentencing. Thank you. Mr. Rennick, you have a sentencing on Ryan January?
Yes, Your Honor. Good morning.
Good morning, how are you? Yeah.
Back in Vegas last night.
Oh, nice. It's hard to feel sorry for you. Did you? Yeah, I feel zero sorry for you right now, but thanks for sharing.
Negative.
Negative. All right, sir, you're Ryan Eric January. Speak up, please. And Mr. January, in cause number 25 DCCR 0370, was previously in court, entered a plea of guilty to the third-degree felony the state jail felony offense of solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have.
Any additions or corrections? So I guess I had a question. I did not realize if we do this on all or if this, but it's showing a requirement to be on the sex offender caseload. But this is not that type of offense. It's not registrable. And so I don't believe that we have been doing those or.
We have.
I'm sorry. Okay. Yeah, I want to rescind that unless there's some reason specifically in this case that there's different you can get with me. Another thing, so I'll take that out of the orders at this time. And then if there's any issues, then we'll make sure everybody knows about it and we'll get back together. The other thing, Mr. January, that is I'm going to order as a condition of your probation is that you get your GED. It is very important to me. It should be important to you. It will help you do better, get better jobs in your life. And so it's going to now be a condition of your probation that you start that process within 30 days of today, okay? So you talk to probation, they'll let you know how to get started on that. And you need to get started on it, complete it, and that'll be at least a good positive thing that happens out of all of this. So again, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm not going to do that. I'm going to follow the agreement, defer all proceedings, and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of those rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, if you successfully complete the probation, the case will actually be dismissed. You'll never have a conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and be sentenced to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's going to call you up to your desk when she's ready to go over all of your paperwork. Good luck to you, sir. Thank you, Mr. Rennick. Thank you, sir. Numbered it. This, Donald Owens, where is it?
It's on the trial docket, Judge. It's on Kelly.
Oh, that's today's. I'm sorry. That's why. Mr. Kelly, Donald Owens.
Morning.
Good morning. Good morning, sir. You're Donald Owens Jr. And Mr. Kelly, will your client waive the formal reading of the indictment? Sorry, it's going a little slow. It's stopped spinning now. Oh, there, shut up. All right. Mr. Owens, in cause number 24, DCCR 1192, you're charged with the second-degree felony offense of sexual assault of a child from March 29th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because they you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kelly? And do you fully understand them? And my understanding is there is no plea bargain. This is just open to the court. Is that correct?
That's correct.
And that there is, in addition, not a waiver of the right to appeal because of that as well,
That's
correct?
yes, correct.
And is that your understanding? That I want to make sure you understand, Mr. Owens, obviously, you know your case is set for trial to begin with jury selection this afternoon. You have every right to have that jury determine if you're guilty and what your punishment is. If we go forward this way, you're pleading guilty and you're leaving your punishment up to me. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection, states 1.
It's admitted. Is there any evidence that Mr. Owens is not competent? In addition to that, Mr. Owens, you do understand that as a condition of your plea in this case, that you will be required to register as a sex offender. And I have that document that you've signed with Mr. Kelly, and y'all went over that this morning, and you understand it. All right. Then I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. So for sentencing, since it's unagreed, do you guys anticipate lengthy hearings, witnesses? What type of time frame do we
Expect
need?
us to call witnesses, Your Honor.
Okay, any more than an hour's worth, something we could do at the end of a docket? Or do y'all anticipate more
I
than
don't
that?
anticipate any more than that, Judge. We may have one witness,
Okay,
but I don't want to confine us to that. If it goes over, we only have, I only expect.
no, I mean, I want that, well, that's what I want to
Yes.
figure out, is if you anticipate that it could be longer than that, then I can set it on a date other than a Monday, when we don't have a trial or something like that. But if you
Yeah.
think y'all can get it in at the end of a docket from 11 to 12 or
If the court can consider not putting it on Monday, that's what we would ask for.
okay, all right, we'll take a look at appropriate date for that and let y'all know that court date. Obviously, anything you think is important for me to know, get that information to Mr. Kelly, and then I will look at all of that and listen to everything when we come back. All right, don't forget to stop and talk to probation. Thank you.
Your Honor. Thank you, Judge.
Mr. Crenshaw, you have Timoteo Castaneda.
Yes, Your Honor.
Good morning.
Good morning. Good to see you.
You too.
Sorry
That's all right.
about the case.
Good morning, sir. You're Timoteo Castaneda.
Yes, Mom.
And in 25 DCCR 0360, Mr. Castaneda is charged with indecency with a child by sexual contact. And what is the announcement?
Judge, if we could come back, we're very close. We're trying to get a probation offer, and once we get that, this will be resolved. We're just not quite there just yet. I think we've only been here once.
Well, it looks like you were hired in May, so this will be the last reset on this case. So, Mr. Castaneda, make sure you stay in touch with Mr. Crenshaw so that any information he gets from Mr. Hoffpower, you guys can go over and we'll get an announcement at that next court date. All right, thank you. Catherine Jordan, Mr. Crenshaw.
Yes, Your Honor. This is going to be a plea. I'm just, we need Mr. Coleman. I don't believe he's here today.
Okay.
If we could just come back on a standard reset. She was trying to get the full restitution, and the good news is she has that. And
So I can set it on an actual plea docket and y'all will get it taken care of on a plea docket?
Yes.
Okay, then I will reset it to a plea docket. Obviously, once it's on that plea docket, I expect it to enter a plea on that day. If anything changes before then, just let me know.
We sure will.
Stay in touch with Mr. Crenshaw. He'll let you know when you need to be back and we'll take care of that. All right, thank you. Let's see, and you have a sentencing on Sidney Lewis, Mr. Crenshaw?
Yes, Your Honor. We're ready for sentencing. The only thing that I would add, Judge, is that we now have an agreed restitution figure for
That's
the court.
my question.
Yes.
What is it?
60,000.
Okay. All right, ma'am, you are Sidney Lewis. And Ms. Lewis was previously here in cause number 24 DCCR 1905, entered a plea of guilty to the third-degree felony offense of theft of property. I've received the pre-sentence report. Have you both had an opportunity to review that report?
The defense has, Your Honor. We have no objections. Yes, Judge.
And Mr. Smith, any objections or corrections?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You are ordered to follow all of the rules and conditions of probation, and that includes paying back the restitution of $60,000. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, you'll never have a felony conviction. The case will be dismissed at the end. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty of the offense and you could go to prison for anywhere between 2 years and up to 10 years. Do you understand? Also, $60,000 is a lot of money to pay back. And sometimes what people will do is they think, I'm going to wait and I'll pay a little bit next year when I get my tax return, and maybe I'll sell this in a year or two, and I've got 10 years, so I've got plenty of time. You will be surprised how quickly that time will pass. And at the end of the probation, you could have done every other thing correctly. And if you don't pay that restitution, and I make a finding that you could have, you can still go to prison for up to 10 years at the end and your probation be revoked. So I want you to pay something on the restitution every single month, because even if it's not a huge amount, it will add up over that time frame. Does that make sense? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. When probation's ready to go over your paperwork, she'll call you up to her desk, all right? Good luck to you, ma'am. Thank you.
Thank you.
And then you've got a David Melanson, Mr. Crenshaw.
Yes, sir.
Good morning, sir. You're David Melanson. And this is 24 DCCR 1186. Mr. Melanson is charged with assault on a family member with previous convictions. And is there an announcement? It looks like you were just hired on this one.
I was, Judge. We're actually on the next setting, I think, going to the state's going to subpoena the complaining witness.
Okay.
I think we'll have a resolution on that day.
Okay.
And I have not heard from her since June of 2024, Judge, but if you would allow
Sure.
me maybe 30 days to send a subpoena.
Yeah.
And Mr. Crenshaw has also presented me with information that he believes there's a non-prosecution affidavit, so we're both going to try to get our hands on it.
Okay. So I'll just do a normal reset to give y'all time to get that taken care of. Make sure you stay in touch with Mr. Crenshaw. He'll let you know when you need to be back. All right. Thank you. Let's see, have we heard from Mr. Adams or Mr. Kimler?
Kimler is still in, next
Jacoby Broussard. Yes, sir. And Langston. Okay.
Mr. Broussard.
Come over here, sir. And she's gonna fingerprint it. Thank you.
Please raise your right hand.
I'm right
Do you swear?
You're right there. Looks just like you.
Making it work. I am moving today, Judge, moving fast.
That's fast.
By definition, I know, huh?
Not like in the old high school days, huh? When you're all-American.
I wish.
22-39417 is called the State of Texas versus Jacoby Damon Broussard. That's you, right? And you were here with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? And we proceed in a summary fashion.
Yes, sir.
In summary, sir, this indictment, which was handed up on March 9th of 2022, it alleges that on or about February 17th, 2022 in Jefferson County, Texas, you committed the first-degree felony of murder by shooting the complainant Christopher Thomas with a deadly weapon, namely a firearm. Do you understand what you were charged with here?
Yes, sir.
If convicted of a first-degree felony, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached in your case where whatever sentence shall not exceed a cap of 30 years in prison. So really, we've got two options, I guess. You've got deferred or unadjudicated probation for up to 10 years in length on probation, or confinement no less than 5 nor more than 30 years. Those are going to be the two options.
Probation is not an option.
And not a deferred.
I don't believe so, Judge.
Okay.
Correct me on
What do you say?
I didn't think so either. I think by statute, it's
Give me any other information so I can know as much about you. I can make a most informed decision on this case, these two cases, and then you can proceed with your life. You understand what's happened today?
Yes, sir.
Okay. We'll see you back in a few weeks. Anything else? That is all. Thank you. Did I give you the right one? I think. Here, the shit. I give you that. Yes, it's. Arthur Small.
These back to you, Judge, because
Thanks. On Arthur Small, Lori, delivery ready? Okay. He's in Preston? Okay. Okay. Here we are. We're just going to do one. One's going to be a dismissal.
There's two. Yeah.
Okay.
Yeah.
I've got only one coming through so far. I've just got you.
Okay, there's two. Hold on, Judge.
416.
That was the old one. Okay, I have the other one. Thank you. Virginia, right?
I'm finding up. Arthur Small, that's you, sir? Come on up. Please come over here and we'll get your fingerprints. Thank you.
Raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, self you got? There's a tongue. And if your right thumb print. And you place it flat here. Don't roll it, just place it flat. Mhm. You get up one more time, it's a whole thumb print. Place it flat right here, right here. I'm still my videos, but you gotta.
Good, well. Was he given information on that case and did he conclude it? Yes.
And you're right. But you'll work on it.
You gotta use two.
Thanks, Frank.
How long ago? Those are some doors, his name? Yeah. Oh, yeah.
Yeah.
I'm going to do that.
Yeah.
I see Mr. Kimler was helping everybody. Was that a second job? He's still working?
He's good helper, Joe. He's gonna send the bill.
Okay. All right, 22-39416 is first call, the state of Texas versus Arthur Small Jr. That's you.
Yes, sir.
Present with your attorney, Ms. Peroso, and the state's attorney. Does the defendant waive a formal reading of this indictment and as well the second case we're going to be handling, 24 CR 702, a third degree felony of assault public servant? Can we proceed in summary in both cases?
Yes, sir.
We will start with 39416 in summary, sir. This indictment alleges that on or about February 17th, 2022, in Jefferson County, Texas, you committed the first degree felony of murder. You with the use of a deadly weapon, namely a firearm. Do you understand what you are charged with in this case?
Yes, sir.
An agreement has been reached in this case that you would be prosecuted for the lesser included offense of manslaughter.
Yes.
Stand by. That boss, this is my boss.
No.
What there is Jimmy's.
No, why?
Different, yeah. Which is a second degree felony, which carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Now. Yeah. Manslaughter is found under section 19.04 of the Texas Penal Code, and this statute provides that a person commits the offense of manslaughter if he recklessly causes the death of an individual. An offense under this section is a felony of the second degree. You understand?
Yes, sir.
An agreement has further been reached by the parties that you would be pleading guilty, sentenced to 8 years in prison to run concurrently with this next third degree felony of assault on a public servant case. And these cases would run concurrently. Is that your understanding of the agreements?
Yes, sir.
If I followed these agreements, sir, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead to this lesser included manslaughter here under 22-39416? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will.
Yes, sir.
And because you are guilty.
Maybe says you're guilty.
So, because I'm guilty.
There's a lot I gotta sign. Okay, we're gonna hold that one in abeyance where we left off and go forward to 24 CR 702. And in this case, in this indictment reads that on or about February 15th, 2024, it would have been like 2 days. No, these were on separate years.
Yes, sir.
Okay. In on or about February 15th, 2024, in Jefferson County, Texas, you committed the third degree felony of assault on a public servant. Do you understand what you're charged with here?
Yes, sir.
Looks like somebody in Jefferson County Jail was assaulted, a guard or some member of the executive branch of government there. A third-degree felony carries with it no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range for a third-degree felony of assault on a public servant?
Yes, sir.
An agreement's been reached in this case as well that you would be pleading guilty, sentenced to 8 years in prison to run concurrently with the preceding murder case. And is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Because I'm guilty.
Show you what's marked as State's Exhibit 1 for each of these 2 cases you pleaded guilty to this morning. Did you sign those documents voluntarily?
Yes, sir.
Understand them, discuss them with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence and without objection admitted. Among other things, each of these cases, State's Exhibit 1 similarly state that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with in each of these cases. You are guilty of these crimes and any lesser included offenses. You were giving up your rights to a jury trial in each case and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God. Correct?
You have to say.
State's Exhibit 1 in each case made a part of the record for all purposes. Pre-sentence report waived.
Yes, sir.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Because I'm guilty.
Show you what's marked as State's Exhibit 1 for each of these 2 cases you pleaded guilty to this morning. Did you sign those documents voluntarily?
Yes, sir.
Understand them, discuss them with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence and without objection admitted. Among other things, each of these cases, State's Exhibit 1 similarly state that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with in each of these cases. You are guilty of these crimes and any lesser included offenses. You were giving up your rights to a jury trial in each case and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God. Correct?
You have to say.
State's Exhibit 1 in each case made a part of the record for all purposes. Pre-sentence report waived.
Yes, sir.
I'm going to follow these agreements if nothing further to add and find in each of these cases, sir, you are pleading guilty voluntarily. You are indeed mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 supporting your guilty plea in each case to find you guilty beyond a reasonable doubt in each of these cases. I now find you guilty beyond a reasonable doubt in each of these two cases. In 22-29-416, the first degree murder, you are stand by. Since take forever. So, in this first degree murder indictment, you are hereby found guilty beyond a reasonable doubt of the lesser included second degree felony of manslaughter as agreed by the parties. And I find you guilty beyond a reasonable doubt of that second degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years in prison. And an affirmative finding shall be rendered on the judgment that a deadly weapon, namely firearm, was used in the commission of the offense. And in 24 CR 702, I hereby find you guilty beyond a reasonable doubt of the third degree felony of assault on a public servant. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years on that third degree felony. These two sentences shall run concurrently, and you will be given credit for all time you have served in connection with these cases. Do you understand what's happened today, sir, in each
Yes,
case?
sir.
Anything else to add?
No.
That is all. Thank you.
Thank you.
Judge.
Yes. Yep, thanks. Hey, when are we gonna get Sanchez's case disposed of?
We want to try it. I like it. I used to read.
Oh, okay. Well, when, do you have a translator you can get? Okay.
So Judge, I think the state needs one as well, so we'll have to kind of coordinate.
Zola Sampson? John?
Sure, I've done the paperwork, sent it through. I'm not sure if it's to give you that, but eventually.
Is that it off, is that gonna be the last one off the trial docket? On pleas, dispositions, I think? Okay, all right. Well, I'm running behind on the other dockets. Zola Sampson, please, and she's here.
He's right there.
Need to say it.
She's right there.
He's walking up right now.
She certainly is. We pleading on both?
No, one is
Which
being
one?
dismissed. We're leaning on the
Oh,
fact.
596. Same, the other is you.
Okay.
Raise your right hand and swear on to dismiss tomorrow. Either your right thumb. You does this flash there. You get up one more time. Thank you.
And come right here, man. Thank you. In 24-596, does the defendant, who's here, Mr. West, and the state's attorney, waive a formal reading of the indictment and arraignment? Can we proceed in summary here? That's.
Yes, Your Honor. Yeah, I'm sorry.
Thank you for that pregnant pause. That we were all excited there for that. In summary, paragraph 1 alleges that on or about November 24th, 2023 in Jefferson County, Texas, you committed the offense of theft. Paragraph 2 goes on to allege, though, that you have 2 or more theft convictions. And actually, I'm reading 3. One in 2005 from County Court at Law 12 of Bayard County, Texas. Another in 2011 from Dallas County, Texas. And in 2011, the County Court at Law out of Bayard County again. So 2 or more. Each time You steal a pack of gum, it's a felony from here on. All right, so a state jail felony means if convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range you are facing on this case and any other theft that you might, which is a good deterrent, I would think, to making sure that you live honestly here on. An agreement's been reached between the parties, so you would be pleading guilty and sentenced to 7 months in the state jail. And then this other case, 24 CR 597, that looks like fraudulent use or possession of identifying information. That case is to be dismissed. Is that your understanding?
Yes, sir.
If I follow these agreements in each case, you have no right of appeal of your cases. Do you understand? How do you plead to this 596 theft case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. And the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses, and you're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 made a part of the record. For all purposes here. Pre-sentence report is waived.
Please, John, yes.
I will follow this agreement and find you are indeed mentally competent to enter your guilty plea. It is indeed freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of paragraphs 1 and 2 of this indictment. Paragraph 2 alleging those prior convictions of thefts in these other counties, and those are true and correct as they are alleged, and you are pleading true and correct to that voluntarily. Is that true?
Yes, sir.
I find this state jail felony supported by the plea and the paperwork, the records filed in this case. I now find you guilty beyond a reasonable doubt of paragraphs 1 and 2 of the state jail felony of theft. I'm following this agreement. You were hereby sentenced to confinement in the state jail for 7 months, and will be given credit for all time served in connection with this case. And let me get to the other case. 24 CR 597. By agreement. Yeah. I don't know. I don't know if this came out right, but the machine's back to playing. Again. That case is dismissed.
Thank you.
All right, anything else?
The only other thing is, I'm not sure if she has to go into custody or not. She has over 7 months credit already. If she does have to go into custody, because she do it on Friday, she has a job and is working. I
think you have to do that. You have to go in, and it's up to the officials to calculate, but there's no objection to that.
No objection from
Okay.
the state.
And it's not an aggravated offense, so I'm going to order you to report into the Jefferson County Jail on or before 6 o'clock PM Friday. If you fail to do that, then you got another new charge that would be added, which you don't want. You got to fix all of this and move on with your life.
If she wants to have a seat in the jury box,
we can call the jail to see if she has to.
Or we can do that too.
But, I mean, just in the case that she does, she could go on Friday.
Yeah, but I don't know of anybody who enjoys going into the jail.
Right.
that-
If she doesn't have to.
Except
She doesn't
employees.
worry about it all day. So just give us some time. Let us call the jail and see what they need from us.
Okay, finally, let me just, I've got Daryl Johnson's case here, Kenneth Jackson and Howard Price, all part of the trial docket, and we have included all of that.
Sorry. Half,
Here is, I don't know, that one.
you want half the staff?
Yeah.
There's. I'm running, see if we can make that phone call real quick.
Thanks. Daryl Albanese. Daryl Albanese is called here on the, well, looks like everybody's in jail. Is that right?
Albanese with, I believe.
Did we take care of all your cases on the trial docket? Okay.
I'm good.
All right. So what are we gonna do on Daryl Albanese?
Your Honor, we need a little bit more time to confirm restitution in that case, and then it
Is
should
that
work
right?
itself out.
How much time?
3 weeks?
Is that good?
That's cool.
3 weeks. We don't need him out. Okay, tell him, I need, what about Alpan?
I think I had that one, Mr. Ham.
25 CR 873. Do we need him out?
No, we don't. I believe he need to talk to.
Okay.
Complaining on that.
All right. Is 3 weeks gonna be good, Mr. Hampton? On Alpan?
Yes, the nature of that, I've got.
Okay, hold on.
The office by then, Judge.
Daryl Albanese and Alpan, we've reset that. They're working on finishing it and disposing of it right now, okay? And
Please.
it's reset 3 weeks and Alpan reset 3 weeks. Jalen Bob.
Judge, I believe that's the one with the mentals.
I think you ordered an updated guys issue, as another, I haven't seen it if it's come through.
The last thing I have is something from UT Health.
Is that January
in
of 25?
January of 25.
All right, so subsequent to that, we had her released under certain conditions with home confinement and all that. The end result was she ended up is charged with having assaulted that caregiver. We were here in July and you suggested we needed a new evaluation on July 28th. I've not seen the motion by the defense or the report by Counselor.
Hey, buddy, I'm looking in the file. I
Not
don't see.
since July 28th, you have.
Oh, I do.
I don't see that.
Okay.
I do that as soon as
I do
possible.
that ASAP though. So just, I do another one. No problem.
Okay, I want to review in 2 weeks.
That's fine. That's
Okay,
perfect.
all right. David Goldbeck.
That's a plea.
Goldbeck, please.
Nice.
Okay, yeah. Hey, as soon as I get it, I can send it out.
Okay.
You see this? Says no. Come on up and we need a fingerprint over here, sir.
Mr. Goldbeck, please.
Worried about other misdemeanors, but I don't think, according to that, they weren't filed.
And I'm just gonna dispose of it case today.
Oh.
It's early.
Come on up right here, sir. Thank you. All right, 25 CR 1017 is called the State of Texas versus David Christian Kobeck. That's you.
Yes, sir.
with Mr. Adams, your attorney and the state's attorney. You're charged with a third-degree felony of stalking. I've got this letter from you sent September 3rd, something about these other misdemeanor cases.
Oh, those.
We can't find any.
They're civil cases. It's dog at large. I meant to send it to the county court, but
Well, we're not showing anything that's filed like that, actually, which may be good for you, but.
okay, I appreciate that.
But let's worry about this case.
Yeah.
Does the defendant who's here with Mr. Adams waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about June 3rd, 2025 in Jefferson County, Texas, you committed the third-degree felony of stalking. Do you understand what you're charged with?
Yes, sir.
Do you understand what you're starting
Yes,
with? What's paragraph 2 go on to allege? And
Go ahead.
Your Honor, that's just a further, the initial.
wait, that doesn't change anything.
No, sir.
This states that you sent repeated electronic communications to the complainant that was reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend another person. Namely, repeated electronic texts with vulgar and abusive language. And also it goes on to state that you also sent obscene nude images and videos that would cause a reasonable person to be harassed, annoyed, alarmed, abused, tormented, embarrassed, or offended. You understand what you're charged with
Yes,
here? Tell me you're not going to do that again.
No, sir.
This is a third-degree felony. So that means that if convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Very serious, obviously.
Yes.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 10 years in prison. That sentence would then be suspended. You would be placed on regular probation for 10 years, fined $500. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this, sir? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir. And she can stay there.
To show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily, understand it, discuss it with your attorney? Or the allegations all true and correct there?
Yes, sir.
State's Exhibit 1 tendered into evidence
So
without objection admitted. Among other things, this states you are mentally capable and competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God. State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived here?
Yes, sir.
I am going to follow this agreement and find, if nothing to add, Mr. Goback, I guess you regret what you did here. This is all fixed. I can't imagine putting somebody through something like this because once it gets into the internet, it's there forever. And that is the gift that should not be giving. Continue to give, but I don't know how you pull it out of the internet. So this person is subject to further victimization.
It was text messages, sir.
Well, this, I'm sorry, this says sending obscene nude images and videos. That's not true.
It was sent to the complainant, Your Honor, just by text. Yes, sir. Yes, sir.
Ladies deserve better respect than this. Come on. All right, shame on you. And fix this. Right. Again, I find you, there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt as third-degree felony of stalking. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years in prison. Imprisonment, that term of confinement is suspended. You are placed on regular probation for 10 years. There will be terms and conditions of probation, which are normally customary for this type of offense. There's a fine of $500. There is going to be, among other conditions of probation, you will complete a program called moral reclamation therapy, which is something that helps you make good decisions. And it teaches you that people can be victimized and harmed by your reckless, insensitive acts, and that this helps you make better decisions in the future. Make sure you follow this. If you fail, your probation could be revoked and you could be sentenced up to 10 years in prison. Do you understand what has happened today, sir? You know, you got a conviction. That's a felony conviction. All right. You know how long you have to carry it the rest of your life. That's why you don't want to do this. Make better choices. Okay. And treat a lady with the respect they deserve, that they should have. Thank you.
Ma'am.
You know, the child, I understood what the child was saying better than some of the things I hear up here. I think the child is an intelligent child. Okay, on this case, there was a second case that was going to be dismissed, right?
Yes.
Any objection to that on Christopher Buckner?
No.
That case is dismissed, 24 CR 2328. You know.
I think that was Goldbeck, Your Honor. Buckner is coming, he hasn't pled yet, but we've signed the paperwork on it. There's a dismissal and a plea on there.
Okay. Do I need Christopher Buckner now?
Whenever you'd like, Your Honor. He's in the queue, ready, but.
Christopher Buckner?
Yes. Just be done with mine.
Is that it? What's the thing? You're not.
What do we do with Green and Reddick?
Which one?
Moses Green and Shelton Reddick.
Reddick is a plea. I sent the plea paperwork for y'all.
Oh, okay. I don't have it yet.
Moses Green, Judge, that's another one I've got to give to the family on before I can make him an offer.
Okay.
But Reddick, I sent you the
Okay.
paperwork.
You or Buckner? Mr.
Yes.
Buckner, come on up here and then we'll get Sheldon Reddick next.
Okay, no problem.
Mr. Buckner, please raise your right hand and swear or affirm to the truth, no matter than it is, and that is something God is, and with your right hand to my heart. Sorry. Like, right there. It's hard for everyone. You get up again?
Assembly line today.
Yeah. Right there. Okay, you can be in front of judge.
Reminds me of that old I Love Lucy episode where she's working on the assembly line on the candy factory And she gets behind and this things start going faster, so she can't stick them in a box fast enough, so she sticks them in her mouth. It gets, her jaws get wider and wider with the candy stuck, and then the assembly line speeds up. Pretty fun. You remember those kinds of things. Okay, on Christopher Buckner.
Yes, sir.
We've got two cases here, and it looks like one is to be disposed of by a plea, and that's going to be 25 CR 357 fraud, fraudulent use and possession of identifying information. And then it looks like a burglary of a building case 2328 is to be dismissed. All right, let's go to 357. Does the defendant, who's here with Ms. Dowdy, waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment states that on or about February 1st, 2025 in Jefferson County, Texas, you committed the state jail felony of fraudulent use or possession of identifying information. And it looks like
We're proceeding on all paragraphs.
it's less than five. So that is a state, less than 5 items of fraudulent information, and that's a state jail felony. Paragraph 2 goes on to allege that you have a prior burglary of a habitation conviction out of this court in 2009. After that was finalized in that case, and that's cause number 99029. After that case was final, apparently you committed the felony of unlawful possession of a firearm by a felon and were convicted of that in the 252nd District Court next door on May 9th, 2016. So paragraphs 1, 2, and 3, if all found true beyond a reasonable doubt, constitutes a state jail felony, punished though as though it were a second-degree felony, which means you would be looking at no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand where you fit in all of this, sir?
Yes, Your Honor.
All right. Just, and we don't. I'm putting state jail felony. And then enhanced to a second degree is in here. And that fits. An agreement's been reached where you would be sentenced to confinement in prison for 2 years?
Yes.
Yes, sir. Is that right, sir?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
How do you plead to this charge? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily on your own free will and because you are guilty?
Yes, sir.
And the prior convictions alleged in the indictment, first of all, paragraph 2, the burglary of a habitation in 2009 out of this court, is that true and correct as it is alleged?
Yes, sir, it is.
And are you pleading true and correct to that allegation voluntarily, knowingly, intelligently, and because it is true?
Yes, sir.
And the third paragraph, unlawful possession of a firearm by felon, a third-degree felony conviction on 2016, which was committed after the burglary of habitation conviction was final in paragraph 2.
Yes,
Is all of that true and correct?
Yes, sir.
And are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney? Are the contents true and correct?
Yes, sir. I did.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, sir, this states you are mentally competent to enter your guilty plea and plea of true in paragraphs 2 and 3, constituting a state jail felony, punished though as though it were a second-degree felony.
Yes.
You are doing that voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You were totally satisfied with the representation by your lawyer, and you were guilty of paragraph 1 and true to paragraph 2 and 3. You are admitting because those allegations are true and correct as they are alleged, so help you God.
Yes, sir.
State's Exhibit 1 made it part of the record for all purposes without objection.
Yes, sir.
Pre-sentence. I'm going to follow this agreement and find you are pleading guilty to paragraph 1 and true to paragraphs 2 and 3 voluntarily, knowingly, intelligently. State's Exhibit 1 admitted here support your guilty plea to find you guilty beyond a reasonable doubt of this state jail felony, punished though as though it were a second-degree felony. I am following this agreement. And you are found guilty beyond a reasonable doubt in this case and hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. Let me ask, there was no restitution?
No, Your Honor, and actually my understanding also as well with the Sheriff's Department that this defendant was very cooperative in helping to get some of the items back as well as other items from different individuals. So, but there's no restitution.
And then once again, you were hereby found guilty of the state jail felony, punished as though it were a second-degree felony, and you were hereby sentenced to confinement to in prison for 2 years in 24 CR 2328. That case is hereby dismissed. You understand what has happened today, sir?
Oh, yes, sir.
Okay. Fix all of this, fix it. You do that. Okay, anything else?
That's it,
That
Your
is all.
Honor. Thank you.
Any other? Who is it?
Villarreal.
Villarreal? Villarreal. It's Nicholas.
Nicholas. Another one. Judge.
I don't have it. You got it now. All right, Nicholas Villarreal, come on up, and this lady needs to fingerprint you, please. So over here, thank you. We have 2 MTRPs.
I didn't swear or I'm tell the truth, the whole truth, and the stuff you got. Ink of your right thumb, right thumb. Okay, place it flat right. One more time. Right here. Okay.
2 cases are now called cause number 20-33933 and 21-37851. Each style the state of Texas versus Nicholas K. Villarreal. That's you, sir?
Yes, sir.
Present with your attorney, Ms. Minaldi, and the state's attorney. Now, there are motions to revoke probation in each of these cases. Does the defendant waive formal readings of these motions? Can we proceed in summary?
Yes.
Beginning with 393. I'm sorry, 20-33933. In summary, and by the way, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
In summary, this case states, and this motion filed on August 12th of 2025 alleges that on September 26th, 2022, in this court, you were sentenced to 10 years imprisonment. That was suspended and you were placed on supervised release for 103 months. I don't even understand what happened there. That's so unlike me. That's an unusual event.
We pulled the records as to the pleas on both this
There
and the
must have
other.
been, there was a good reason for it because it was an odd thing to do. But is that true and correct?
I believe so, yes, sir.
Which means you were found guilty, but any sentence of confinement was suspended and you were placed on probation for 103 months. Allegation number one, and I'm going to hold that just for a second. Let's go to this next case because it looks like the allegations are similar on the motion.
Yes.
There's another motion to revoke probation in cause number 21-37850. And in summary, if we may,
Yes, Judge.
and waive a formal reading of, in summary on that case, also on September 26th, 2022 in this court, you were sentenced to 2 years in the state jail and that was suspended for 4 years for the offense of illegal possession of a controlled substance. Is all of that true and correct?
Yes, sir.
In each of these cases, sir, allegation one in the motions to revoke probation similarly allege that you committed the offense of battery. That doesn't make any sense.
That's a Louisiana charge for you, Judge.
No, battery of a dating?
It's someone he was dating.
I know that, but battery of a dating and nothing else.
That's how they worded it, Ron.
Yeah, okay.
I went to school over there and I can't make sense of it.
Battery of a dating, but that's a verb. The dating is a verb. I mean, battery, it should be a noun. But we're talking about Louisiana, God bless them. Okay. All right. Out of Lafayette Parish, Louisiana. I mean, much of my family's from Louisiana. Maybe they were the cause of this, but I don't, of this confusion, but do you understand what you're charged with here? It's obviously battering of a dating relationship in a dating relationship, I'm sure. Is that allegation true and correct, sir?
Yes, sir.
Are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
Do you understand that a knowing and voluntary plea of true to one or more violations of probation, and this would be such an allegation would be in violation of condition 1 of your probation order that you signed with me, which states don't commit another offense. This would be an offense from Louisiana, and that would be a violation of your probation, which could subject you to revocation of probation, and your probation could be now revoked, and you can be sentenced up to 10 years in prison.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
To allegation 1. I find you were pleading true voluntarily and knowingly, and you understand and appreciate the consequences of pleading to allegation 1. And then we'll just go one more to 2. Allegation 2 states you committed the offense of resisting an officer in Lafayette Parish on or about November 12th, 2023 in violation of your probation order 1. Is that true and correct as well?
Yes, sir.
And are you pleading true and correct to that voluntarily because it is true as well?
Yes, sir.
It has the same consequences. That would be enough to grant the motion to revoke probation. Your probation could be revoked and you could be sentenced up to 10 years in prison in each case for that violation. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true to the motion to revoke probation in each case. And there's an agreement that states your probation would be revoked, sentenced to 5 years in prison. Is that true and correct?
Yes, sir.
If I follow these agreements in each case, and that's true in each case, then you have no right of appeal of your cases. Do you understand?
Yes, sir.
I'm looking at the agreement. It says he would only be pleading true to one. Can we
We can
plead?
add number two, Judge.
And
just
two.
For the record as well, for the state jail felony, this revocation punishment for that was agreed upon is 18 months state jail.
Okay.
And then 5 years on the 3rd-degree felony, but they would run concurrently.
That's accurate, Judge.
Okay. So I'm gonna go on this one first in 33933. If nothing else to add, I'm going to find there is sufficient evidence supporting this motion to revoke probation granted by a preponderance of the evidence or greater. Allegation 1 and 2 is proven true. Your probation is hereby it was proven true by a preponderance of the evidence or greater. Your probation is hereby revoked. And following this agreement, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years in this case. You understand what has happened?
Yes, sir.
This. And following this agreement, thus you have no right of appeal of this case. Do you understand?
See. Let's see it on mine.
And we go to 37850, and that's a state jail felony. And an agreement has been reached in this case where you would be pleading true to allegations 1 and 2. Your probation would be revoked. You would be sentenced to 18 months in the state jail to run concurrently with the preceding case. Is that your understanding of the plan?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
Show you what's been marked in each of these cases as State's Exhibit 1. Did you sign that voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in each of these two cases without objection admitted. All right, it states.
We were able to get into Emily's emails. The defendant did send an email on Monday, September 29th at 12:47 PM. Quote, please help me tell the judge, ... That was it.
Were you drunk?
No, that was actually my husband, and then he ended up calling her.
You got a drinking problem. I mean, I'm sorry. That's what I'm seeing out of this whole thing. I'm not trying to make you feel bad. You're making a lot of excuses. I think you're rationalizing. I don't know why your husband thinks he can send something to probation on under your name. I know what's going on. I can tell. I'm serious. I'm not trying to make you feel bad. I'm trying to figure out which direction I need to go. You didn't show up because, as far as I'm concerned, you were drinking within 3 days and you knew you'd be positive. You can give me all this about not showing up because your husband threatening you. Your husband, who was threatening you, I think you said earlier, is now sending emails. On what day was that?
September 29th, the last.
September 29th. And he's sending emails and you're telling me he's threatening you, and September 29th was the day the day that you were supposed to test? Young lady,
I was actually moving out and moving in with my mom for a little bit with the kids. So it'd be easier for me if she's willing to help me with everything, now that she knows the gravity of my situation.
anything else? I know it's a tough one, because she's almost forcing my hand here. Anything you want to say?
The jail, but if the kids need you, I don't even fall apart the house.
What are you thinking?
When I had a conversation with Emily, Emily's recommendations to jail.
Been taking this seriously from day one. I've been doing everything. I've been working so hard from 3:30 till 3 in the morning every day just to try to maintain all of our bills. I got my kids.
When did you lose your job?
It was August 13th, but I wasn't late. It was for me leaving early because I kept getting out at 30 in the morning. I had to leave early a lot of times for the kids. My boss, he didn't want to let me go. It's just how the point system works. I was always there. I was always a hard worker. They didn't want to let me go. He even told me if I put my 2 weeks in, he hired me right back. But I couldn't afford to stop working at the time. I had to keep going. My understanding was that my husband, talking to his chairman every day at work, that they were gonna have him start back work last month, but they're just dragging it on, and they keep telling him just be ready to work, and it's just creating, all this, debts that we're getting and creating him to on this mental breakdown, and I've been having to hold it all together on my own. I have a dream, that's why I was lost the first time I had, and why I don't desire to forget all important, Your Honor. Honest to God. I just have a really hard time balancing all this. I had no choice to ask my mom for help, and he had no choice to ask his peers that he doesn't even talk to for help to pay our mortgage, so we don't lose our home. That's all that's been going on right now. I have 5 interviews this week, but I'm determined to get a job. And he's supposed to start work next week for his mom's husband's work. He's supposed to go out there and just work for him until he gets called back for GM. So that we have something to get us by until then. But I plan on going to work. I want to get a different job other than working from 3:30 to 3 in the morning so I can be there to take the kids to school because they go through all the different schools. And I wanted to work in the morning.
What time was that email?
12:47 PM.
In the afternoon.
Yes, the DNA would be open between 5 and 7 PM that night.
No, why didn't you go there? So you're saying your husband's sending something to probation, or at least this is,
And I wasn't able to go because it was only from 6 AM till 9. I could only go between 5 and 7.
September 29th.
And I was
Monday.
here.
It was a Monday.
They're always open morning and evening.
Why didn't you go there then?
I couldn't go anymore. I was here. So I
At night? Why didn't you go at night?
can only go between 5 and 7.
At night?
Yeah, I couldn't get there. I didn't have any money. I didn't have any transportation. I tried calling everybody. I couldn't get there between 5 and 7. I had all the kids. I had no money. I had no transportation. Everybody was calling me the next morning. My mom was waiting. Usually she's there all the time. Like I could get a hold of her at anything. At any time, but I couldn't get a hold of anybody. I've been taking this seriously. I don't miss anything. Even with the sober league.
You missed it.
I made sure I did everything right.
Ma'am, stop,
Thank you.
stop, stop. I don't know what's going on with you. If I order a sober link, you're gonna tell me you can't afford the sober link. If I order. Well, you needed to afford the,
Help me. I could have a job by the end of this week. I know I can.
Lisa. Can you hear me, Lisa?
Yeah, I can hear you.
Will Gibraltar send? I don't know where she's gonna go if I give her 3 days. Do you, where Gibraltar will want to send her?
I'm not sure. I can call and check.
Please do. When is probation scheduled to expire? October 18th, right?
Yes.
Judge. Can you hear me?
I can hear you.
Okay, they said they normally would go to Flat Rock, but Flat Rock does not accept females, so she'll go to or to downtown.
I thought you were gonna tell me that. That was not the answer I was looking for. I do not relish sending people to jail. I don't relish it. But you gotta wake up. No, you're gonna serve 3 days jail. We're gonna put right on the commitment until 5 PM on Wednesday. You're be on a SoberLink device for 75 days. To be on SoberLink by 10 AM. What time do they open, you know?
7 a.m.
By 10 AM on 10/9/25. You're to pay additional costs of 50, additional probation fees of 80 because I'm extending your probation until February 18 of 26. So you're gonna be on probation until February 18, 26. You're gonna pay additional costs of 50, additional probation fees of 80. You're to serve 3 days jail from now until 5 PM on Wednesday. I just want you to think you're to be on a SoberLink device for 75 days until October 9th. Ms. Wyachek, you seem like a really nice person. I think you got to get your life in order. I don't know what else to tell you. I don't want to. That's the last thing I want. I'm sorry, ma'am. I really am sorry. I really am. Good luck. I'm sorry. And you have to be on that SoberLink by Friday morning at 10. So you're gonna be back on a SoberLink by Friday morning at 10 AM. On Thursday morning, rather.
So
You're getting out Wednesday at 5 o'clock. Yes, ma'am. Right now.
I have to have somebody take me to jail right now.
Yes. You're not gonna have them. We're gonna lock you up. I'm sorry. We'll let you make some calls. I promise you. Okay? What do you guys need from me? You need something?
Yeah, sorry, Your Honor. On your order, you got the judgment of 1350, but at the bottom on the explanation.
I know, because I'm ordering that the plaintiff get 1350, and I'm saying Michigan Title to cut a check to him and his wife for 1350, and them for 1650.
Okay. So you guys thought too? Yeah.
So you're gonna take that over to Michigan Title?
I thought it was transposed. I thought Mr. Bott was getting the 1650.
No,
And they were getting.
no. And you have to have them call me, please, if there's any issue, all right? And I know them, so I'm sure they won't have
So
he's gone. No,
he sold his interest to Capital Title. And she did a year and a half ago, probably.
you're kidding.
He retired as the end of, I think September 30th was the last day.
What is he, 50?
I'm 55. I've known Adam his entire life. Adam's,
What about Rick Smith still over there, though?
they keep Rick out.
Uh-oh.
It wasn't.
Wait, don't say nothing. We're on YouTube. We're on YouTube. Don't say nothing. We're on YouTube, get me in stream, so. No, that's okay.
Yeah, are we still live?
Yeah,
Yeah.
okay, she'll stop it.
States, among other things, that you are giving up all rights of appeal if I follow these agreements, and in this case, I'm going to follow this agreement as well. Anything else to add?
No.
If not, I'm going to make the findings that there is sufficient evidence supporting this motion to revoke
that page, sorry. For $926.18 plus $100 in costs. So a total of $1,026.80.
All right, so it appears that service has been proper, so you can put that right in your default judgment, it appearing that service of process on garnishee defendant was proper. And in accordance with the Michigan court rules, defendant having failed to respond. Garnishee defendant, Good Helpers Today LLC, having failed to respond, judgments entered in favor of the plaintiff and against the garnishee defendant, Good Helpers Today LLC, in the amount of 102,618. You can submit that, okay? Thank you very much.
And Judge, Attorney Paul Fleischer told me to tell you to said hi and hope everything's going well.
We'll give him my best.
Seeing you.
Yeah, he's a good man. He called here about something not long ago and it was good. He's just a good man. Thanks a lot. Thank you very much. You too. All right, what do I have here? Do I have another one? I got some lawyers out here. Before I go on, do I have anything else down there? I've got Ryan Botts. Is Ryan Botts here? Yeah. Is Kelvin Pruitt and China Badiak here? Okay. Do I have anything else down there, Amy?
You call Barclays, the 9 o'clock Barclays, that was.
Yes, you did.
You called her.
Counsel, what are you here on? Marlene Jackson?
What am I here on?
9:30. I can't staff going on things.
Michael Thomas. is coming against me with Michigan First Credit Union.
Anything else down there? Oh.
Staff of 9:30.
There should be.
You should still have 9:30. Yeah, I got it. I'm sorry. I'm telling you, the e-filing I'm not a fan of. Never have been, never will be. Michigan First Credit Union versus Marlena Jackson, 2502730.
Good morning, Your Honor. Michael T. Mamet, PA 1102 on behalf of plaintiff.
Good morning, Ms. Jackson.
Hi, I just want to let the court know that I just,
You need to tell me your name, ma'am.
oh, sorry, Marlena Jackson. It's my first time ever having to do this.
That's okay. Do you have a pretrial order down there? I thought you were a lawyer.
No, I do work, but I'm not a lawyer. Project manager.
Okay, all right. Let me take a peek at this. Counsel, do you two want to talk?
Your Honor, if the defendant would like to settle it this morning, I can absolutely do that.
You want to talk to him, Ms. Jackson? See if you can resolve it?
Unfortunately, I have retained an attorney and I am in the process of filing bankruptcy. So I will not be able to clear that today.
All right.
And my attorney name is Charles Snyder.
I'm gonna adjourn it 2 weeks. Is he gonna file this real quick?
I don't know, but we're working hard. I have to get my taxes over to him, but we're
I'm
almost.
gonna adjourn it 3 weeks, defendant filing bankruptcy. If not, I'm gonna set dates and set it for trial, okay? Lisa, Linda, what do you got for me?
Well, we'll have to go out 4 weeks, Judge.
Okay.
We'll do November 3rd at 9 o'clock.
No, November 3rd at 9 a.m., okay?
All right, thank you.
Thank you very much. JP Morgan Chase versus Michelle Young, also known as Michelle Monteleone. 2502398. All right. Who do I have here? Mr. Brown out there or Mr. Nate?
Yes, Your Honor. I guess I didn't have this one on my docket, but I'm happy to cover that one.
Another pretrial. Oh, wait a minute. Oh my God. What date is it? All right, let's see here. All right. All right, Mr. Nate is for plaintiff. Is Ms. Young your name?
Michelle Young.
Good morning to you.
Good morning.
770. All right. All right, did you two talk, Mr. Nate? Do you wish to?
We haven't, but if Miss Young would like to, I'm not opposed to meeting in a breakout room with you real quick.
Sure. I've never done this before, so I don't know how that works. I will say I did try calling a few times, offering payments. I've started 200 and then I looked for my.
Why don't we have you guys go into a breakout room? And
Okay.
then you can see if you can work it out. If you can't,
Okay.
then I'm gonna go ahead and call the case.
Okay.
That'll work.
Thank you. Do I have anything else down there? I got nothing else. Where are the rest of the files here?
Yeah, you have 10 o'clocks. And there's another 9:30 Credit Corp versus Bridget Baker.
Mr. Box, they're out here for 9 o'clock.
Yeah, bots is the small claims. I was gonna kind of wait.
You have 3 for 10 o'clock.
You see Bridget Baker up there, Judge?
Do I hit what?
Bridget Baker?
No.
That should be at 9:30. Here's the one.
I already took that, Ms. Baker. Oh, maybe not. Okay, Credit Corp versus Bridget Baker, 2501007. Is Bridget Baker here?
Your Honor, she was here. I don't know what happened to her.
There's an hour waiting for that. That's.
Who's here for Credit Corporation? Is that Mr. Nate? It might be.
Unidentified people on the waiting. I don't know if either of those would be good. Want me to bring them in?
Sure.
Your Honor, I think she just logged in. She's the iPhone.
Ms. Baker, your name? You got on mute.
There I am. My name is Bridget Baker, Your Honor.
Let me call this again is Credit Corp Solutions. Is that Mr. I think that might be Mr. Nate handling that. So I'm gonna, he went into a breakout room with somebody else. And I'm gonna pass that case right now.
Okay, thank you.
Edward Rose Associates versus The Landings, Michaela Manatek and Deontay Jones, 2403372.
Good morning, Your Honor. Christopher Sosson, spelled Sossong, P59383, appearing on behalf of the plaintiff.
The two of you, your names? Mr. Jones, you gotta take that hoodie off, please. Ma'am, your name?
Michaela Manatic.
I just wanted to clarify my ruling, Mr. Sossing. I enter judgment. I want to be clear about this. Mr. Jones, where are you? Come on. Where'd he go?
He was changing his foot, Your Honor.
Not hold it down.
All right, Mr. Jones, your name?
Deontay Jones.
Counsel, I just wanted to be clear. I had no knowledge at the time that we had this trial that there was a default entered against Mr. Jones. I'm setting it aside. And I just want to be clear about that. I think it kind of went without saying, but I did not know that there was a default judgment or default that had previously been entered against Mr. Jones. So on the court's own motion, I'm going to set that aside. Set aside the default judgment, and I'm running the judgment should indicate that it's against both parties. I just wanted to clarify that. I filled out the judgment. I did not know that there was a default. Would you please send me an order setting aside the default against Mr. Jones, whether it was a default or a default judgment? I believe it was just a default.
It was a default judgment it was a default judgment. Absolutely, Your Honor.
So I'm just going to ask, I'm just trying to make the record clear here. Again, Mr. Jones, I want you to understand me. I did not know that you had a default judgment that had been entered. I'm setting it aside. I believe you guys paid the judgment, the amount of $243.50 or what, some odd cents that day. Did you not?
No, we did not pay anything yet.
Why didn't you pay it? I thought you were going to pay it that day.
We didn't have the money right then and there. I haven't gotten paid yet, Your Honor.
Listen, send that money in so you don't have garnishes, wages garnished. Will you please?
Clarification on behalf of plaintiff, Your Honor. The court, it looks like, did enter a judgment on September 24, 2025 for $318.56.
Okay.
Now the court did note, the court notes in the case caption that the judgment is entered against defendant Michaela Manatek, but the address also includes Mr. Jones as a party, but the judgment just appears to be entered against co-defendant Michaela. Did the court also want me along with?
Yes. Yes, I want you to prepare an order setting aside the default judgment against Deontay Jones and an amended judgment that indicates the judgments against Manatek and Jones.
Very good, Your Honor.
Sincere apologies for screwing this up.
No problem at all.
So get them the money, and then you don't have to worry about people garnishing wages, folks. I mean, you kind of won this, if you know what I'm saying. You did kind of win. You did win. All right, that's it. That's all I have to say. Have a great day. Nice to see you, Mr. Sosson. Good luck to you, kids. Wish you well with that baby. Thank you. LVNV versus Antonio Hernandez, 2503623.
Me is Antonio Hernandez.
Right, good morning, Mr. Hernandez. Where are you again?
Good, good. Is the problem is that my language is Spanish? Please, is one translator?
Wait a minute. Do you understand me?
My English little.
Well, I
Okay.
can't go. Mr. Nate, your name?
Good morning again, Your Honor. Preston Nate, P778884, appearing for LVNV on this one.
I'm gonna go ahead and we're gonna get an interpreter. I don't know what else to do.
That'll work.
Get an interpreter for the pretrial. So we will need a Spanish interpreter, however long it's going to take us to get that, Linda. We'll set this out for. Okay?
Yes.
So I am getting you an interpreter, Mr. Hernandez.
Okay.
Interpreter, Spanish, Espanol interpreter, okay?
Yes, yes,
And-
please.
And we'll adjourn the pretrial until, want to do November, Linda?
How about if we do November 3rd at 9:30?
Perfect. November 3rd at 9:30, okay? November 3rd at
Okay.
9:30 will be the new pretrial date, okay?
Okay, thank you. Is there one email for new court?
We'll email,
Tell him-
we'll mail you something.
Yeah, he'll get a notice in the mail.
Okay, perfect.
Thank you.
Thank you. Good day, sir.
Have a good day.
You too. Thank you. Bye.
Okay. Give me 1 second, please, everybody.
Noviembre primero.
Okay, now let me recall Credit Corp versus Bridget Baker, 2501007.
Good morning again, Your Honor. Preston Nate, P778884, appearing for Credit Corp.
Bridget Baker?
Yes, I'm
Your
Bridget
name.
Baker.
All right, so we had a default judgment, defendant failed to appear. And this is, you want to proceed with your motion, ma'am?
I do. I wasn't able because I was in court for another matter and that dealt with one of the children. I would like to proceed. I've been trying to reach someone at
Did you
Credit
call the
Court.
court?
I did. I came over to the court.
Slow down.
Mhm.
I'm asking you, when you knew you had a court date that was in conflict, did you call the court?
I believe so.
Well, do you know? You would know, wouldn't you? You didn't call the court and you didn't show up. You can't do that.
Well, both the court dates were the week of the 20, I think one was the
You can't just
26th.
not show up. Was that a default entered, Linda, because she didn't show up for a pretrial or what?
I believe so. Let me double check for you.
I had a motion, I thought, on this, but I don't see it right now.
Yes, it was because she failed to appear.
And she filed a motion to set aside default, is what you're telling me.
Yes.
Do you have, can you bring a copy of that down? Have
The default or in the motion?
the motion to set aside the default.
It's not in there?
I don't see it.
Okay,
Okay.
I'll have Gina run.
Let me double check before I send you on a wild goose chase here.
Should be towards the back.
Yeah, you said confusion. I'm sorry, Linda, it is.
Okay,
Like confusion of court date. That's a lot different, Ms. Baker, than having it. Ms. Baker,
Yes, I understand what you said.
you told me you had another court date. Now you're saying you confused the court date.
I had 2 court dates that were within that same week, and I confused the one date for the other.
Do you know do you know, ma'am, do you owe this debt?
I do owe the debt, and I was trying to reach out to credit court after our initial court date to make some payment arrangements with them, and nobody returned my call.
Well, confusion of the court dates is one thing. I could go out of my way to find good cause, but the problem is you don't have a meritorious defense and you didn't set one forth. So I'm going to deny the motion to set aside default judgment. The judgment will remain in full force and effect. Now, let's figure out how much you could afford to pay weekly, bi-weekly, whatever the case is. How much can you afford to pay, ma'am? Are you working?
I am not working. I'm on a fixed income. I receive Social Security.
How much can you afford to pay monthly, ma'am?
Possibly $75 to $100, and maybe towards the beginning of the year, just pay the debt in full.
How about if we do this? You pay $75 per month. You have questions or an objection to this? This is what I'm going to tell her, Mr. Nate, but I'll let you ask questions. I'll let you argue for more. $75 a month starting November 1 and the first of every month thereafter, with all monies due, let's say by March 1 of 26. Is that fair, ma'am?
I think it's very fair. You
Then
said March.
Is that all right with you, Mr. Nate, or do you want to argue for more or ask her questions?
No, I think that she's already probably answered my questions with her social security income. That's fine. I don't have any objections to
So,
that.
so we're going to set up an installment payment where you pay $75 per month, ma'am. Default judgment to remain, and you'll pay $75 per month beginning November 1, 25, with all money due by March 1, 26. Okay?
Okay, where do I pay this? Do I pay it over at the courts or?
No, you pay it to them directly.
Yeah, you'd pay our office at Stanger and Stanger, Miss Baker. So you can call it in, mail it in, pay it online. However you like to do your payments is fine.
That
Thank
sounds good. Thank you. I've been
Thanks.
trying to reach out to you guys with no avail, so I don't have a problem with that.
Okay.
Have a good day, Ms. Baker. Good
Thank
luck.
you very
Thank you.
much.
Mr. Nate, do you have another one here?
This the JP Morgan versus Michelle Young is ready to go.
Let's go. JP Morgan versus Michelle Young.
Yep.
Also known as Michelle Monteleone, 2502398. Ma'am, your name?
Michelle Young.
Counsel?
Preston Nate P77884 appearing for JP Morgan.
Any resolution?
Happy to say we did come up with a payment plan that works fine for both parties. Miss Young is going to go ahead and pay $300 a month starting October 10th until that balance is paid in full.
And is this by way of a consent judgment?
It'll be a consent judgment. We'll go ahead and get that prepared and sent over to Miss Young.
And how much do you, can you go through the damages with me?
So the only damages is going to be what was paid for in the complaint, $7,707.39. Chase does not have us attach any of the court costs. Or interest, so that would just be all the damages we're seeking.
Ma'am,
Yes.
do you agree that you owe that amount 770739? And do you wish to enter into an agreement, a proposed consent judgment that will then become a judgment when I sign it, where you're required to pay $300 per month beginning October the 10th of 25 and the 10th of every month thereafter until paid in full?
Yes, I agree.
And does Mr. Nate have your permission to sign your name to a proposed consent judgment?
Yes, he does.
So you don't even have to send it over, Mr. Nate. You can just send it to me for signature with you putting her name on there. I wish you guys well. Is there anything else, Mr. Nate?
No, Your Honor, that's great. Thank you.
Ms.
Thank
Young,
you.
anything at all?
No, thank you, Mr. Nate. Thank you so much.
You're welcome.
Good
Yep.
luck, folks.
Thank you.
I think I've got nothing left other than the small claims.
Is there 10:30s?
Judge, you have a 10:30 and an 11.
Nice. Okay. What? Discover Bank versus Michael Curtis, 2500901.
I did not have Mr. Curtis check in.
The Google Pixel 7 Pro phone. Who is that? What's your name, sir?
Cobbs.
Okay, next time you show up on Zoom, you have to have your name on there, okay? If everybody does that.
Yeah, I usually do. I usually do, but this time it didn't give me that option for some reason.
Okay. Well, do I have
Just-
somebody here from
yeah.
Discover Bank?
It is set out.
You stepped out? All right. I'm going to take a 5-minute recess. And then I'm coming back. And I'll start the small claims, I believe. I might have to do Discover Bank first. So everybody stay seated. It is 25-2. I will be back here at 1:45.
Paperwork.
I see. You signed paperwork and we had rescheduled so you guys could take care of that. It looks like you did. So you have to comply with the terms of the conditional dismissal, okay?
Okay, I was just applying to the review hearing that was scheduled today. Okay, I see what's going on now.
Yeah, I scheduled it just in the event that we did not receive the paperwork, but we have. So you're all set.
Okay, all right,
Just
thanks a lot.
comply with that order. Okay, good luck.
Thank you.
Do I have anybody here for Synchrony Bank? Brian Murray here? Let me take this one. You can come on up here, sir. Discover Bank, have a seat at the table versus Michael Curtis, 2500901. I thought that was yours, counsel. No, you can have a seat over there, right there.
One versus Michael Curtis.
Well, was there a substitution of? What's the case number?
00901.
Yeah, that's the case I'm calling. I don't know, we still have Discover Bank in the computer versus Michael Curtis, 2500901. Come on up here, Mr. Curtis.
You have two Michael Curtises? Because there's one Michael Curtis over here.
Are you from Clinton Township?
Yes.
Come on up here to the podium.
Yes, sir.
Tell me your name, please.
Michael T. Curtis.
Linda, your name, counsel?
Good morning, Your Honor. Jeffrey Beers, P 41693 on behalf of plaintiff.
What? Yes, Your Honor, what's wrong?
What's going on here? Do you know why the caption says Discover Bank versus Curtis? Maybe didn't
Maybe
Capital
we
One
didn't get a, or
substitute in though?
It merged. Discover Bank merged into Capital One.
Did you submit paperwork to us telling us that so we could change the caption? Did I sign an order?
I believe we did.
Well, what to tell you, I've got Discover Bank versus Curtis. That's what I put on the pretrial order that was dated July the 15th. We never received, I don't believe, unless you tell me we did, Linda.
Your Honor, I'm gonna look right now.
Is this the only one you have?
Yes.
Okay. Let's try to put the terms on right now.
Yeah, I had an opportunity to speak with the defendant, Michael Curtis, this morning in the hallway. We agreed to a consent judgment as follows. In the amount of $19,795.29, with the additional order that defendant shall have the right within 21 days to file a motion for installment payments with the court. And we both signed it and have a signed consent judgment.
And you have it in paper, right?
I do.
You can hand that up, please. So, sir, he tells me that the two of you are agreeing to consent to a judgment in favor of the plaintiff and against yourself, correct?
Yes, sir.
Hang on.
Oh, no problem.
Is that what you want to do?
I'm still unaware of the exact terms of it as far as, I know I've been working with Accredited Associates of America, a debt consolidation firm, to take care of my debt, and I've been paying on it since 2023 of July. So I'm just a little confused as far as,
Well,
I've been paying for them every month $500 to.
have they been in touch with you?
We will reach out to them. We will work with them.
Well, they've got consent judgment in the amount of $19,795.29. Damages, which include 19,466.39, court costs of $328 plus interest at the rate of 13% per year from date of filing judgment entered against defendant. Defendant shall have the right to file a motion for installment payments with the court. So I just want you to understand, once I sign this, if you don't file a motion for installment payments, I don't know what they're going to do, what they're going to say, but they could at that juncture, they could go ahead and they could start garnishing wages. Do you understand that?
I do. I've been working with them for, I don't really know what play to play here. We will reach out to your debt settlement company because they've been trying to get settlements for quite a while as far as an agreement with them, and I pay through them, sir. So I don't want
You're gonna have to file a motion for installment payments, okay?
And what does that entail?
You can go down the hall, you can fill out a motion for installment payments, and then I'll have a hearing and determine how much you can afford to pay. But the debt settlement consolidation companies, they can do what they want.
Does that change anything?
I don't have one thing to do with them.
No, I understand, sir. I understand.
Not one thing to do with them. And I hear these stories all the time where they're not doing what they're supposed to do. I'm not saying that might be the best debt consolidation company in the country, but
yes,
it's not for me to get involved with. They're not lawyers and they don't file appearances on cases. I'm going to go ahead and sign the judgment. You agree to those terms, correct?
Yes.
Okay, and you signed that, right?
Yes, sir.
And you read it.
I did.
Anything else, Mr. Beers?
If there's nothing further, I think you would like a copy before you leave.
We'll give you a copy. If you can go down the hall, we'll give you a copy, all right?
Yes, sir.
Thank you very much.
Thank you.
Do I have anything else besides the small claims cases? In Wyatchek, I know that. Brian Murray versus Synchrony Bank Legal Operations 2503754.